I'll open this meeting. Thank you, first of all, for your understanding, everyone. We just had a few votes in the House of Commons. J'ouvre maintenant la séance. Bienvenue à la...
I will now call the meeting to order. Welcome to meeting number 54 of the House of Commons, Standing Committee on Public Accounts. Pursuant to Standing Order 1083G, the committee is meeting today in relation to its study of Report 9, Vaccines for COVID-19, and the motion adopted on Thursday, March the 9th, 2023.
I'll read this motion. The text of the motion adopted, quote, that the committee invite at the earliest opportunity the representatives of Moderna, Sanofi, Pfizer, Medicago, AstraZeneca, Johnson & Johnson, and Novavax, and the law clerk and parliamentary council in view of its study on Report 9, COVID-19 vaccines, with 2022 Report 9 and 10 of the Auditor General of Canada. As members are aware, the committee is currently debating the motion of MP Nathalie Sinclair-Desgagnés, which I will not read, but you're all very familiar with it. Just to bring members up to speed, AstraZeneca, Johnson & Johnson, and Novavax declined the invitation to appear, but they did send letters to the committee, which you have and can consider. You should have received these from the clerk in both official languages. I'd now like to welcome our witnesses. Thank you very much for agreeing to appear today. From Medicago, Inc., Toshifumi Tada, President and Chief Executive Officer by video conference. Thank you very much for being here. Moderna, Inc., Patricia Gauthier, President, General Manager, Canada. Pfizer Canada, Nadja Sampson, President. Fabien Paquette, Vaccine Lead, NRMA Vaccines and Antiviral Portfolio by video conference. And Sanofi Canada, Jean-Pierre Bellet, General Manager, Vaccines. Also with us today, to my right, is Michel Bédard. He is the interim law clerk and parliamentary counsel. He will not be making an opening statement today, but he is here should there be any questions. Each of the witnesses will have 5 minutes for their opening remarks. We will start with Medicago, and then go to Moderna, after that Pfizer Canada, and then Sanofi Canada. Mr. Tada, you have the floor for 5 minutes, please.
Thank you very much. Ladies and gentlemen, I would like to thank this committee for inviting me to attend as a panel of witnesses today. My name is Toshifumi Tada, President and CEO of Medicago since May 2022. Before that, I was the director of the board for Medicago for 4 years, representing Mitsubishi Tanabe Pharma, our majority shareholder. First, I'd like to share with you that our shareholder, Mitsubishi Chemical Group, announced last month that it had decided to cease and proceed with an orderly wind-up of our business and operations. Medicago is a Canadian biopharmaceutical company with sites in Canada and United States, specializing in the research and development of new vaccines using plant-based virus-like particles technology. Our vaccine for prevention of COVID-19, Covifense, was approved by Health Canada in February 2022. This was intended as the first commercial product. We had been preparing for the transition to commercial scale production. However, considering the significant changes to the COVID-19 vaccine landscape, the global demand and market environment for the COVID-19 vaccines, and Medicago's internal challenges in transitioning to commercial scale production, Mitsubishi Chemical Group determined that it will not pursue the commercialization of Covifense. They also judged that it was not viable to continue to make further investment in Medicago. It would have required hundreds of millions of dollars and years of testing to enable commercial scale production. Therefore, we will cease our operations in the United States on April 14th this year, and in Canada on June 2nd this year. Next, I'd like to clarify Medicago's position on the requested disclosure of the adjuvanted vaccine supply contract, which we executed with Public Services Procurement Canada on November 13, 2020. Given the cessation of our operations, our position is not to oppose the disclosure of unredacted copy of the contract to the committee. However, we request that the committee shall keep the confidentiality of our commercial and technical information in the contract in the context of its audit. As we did in collaborating with PSPC to answer and access the information request in February 2021, we must stress again that contract contains our commercial and technical information that ought to remain confidential. We request the same grounds be given full weight and consideration by the committee, and that committee consequently ensure that all our commercial and technical information be kept confidential. While we are working to wind up operations, some of our tangible assets, including facilities and equipment, or importantly, intangible assets such as our intellectual property rights, may be sold or transferred to other organizations. We must ensure that unauthorized disclosure of our confidential information will not jeopardize or lower the value of such transactions. More specifically and in summary, we request the contract information redacted in our answer to PSPC in the context of access to information request of February 2021 shall be kept confidential for the following 3 reasons. First, such information is in and of itself confidential and has consistently been treated as such by PSPC and Medicago because it concerns our pricing, supply quantities, facility allocations, and availability plan, which has direct commercial application. Second, the disclosure of such information could reasonably be expected to result in material financial loss to us, to prejudice our competitive position because it would permit our competitors to gain valuable insights into our proposed product and marketing strategies, and would unfairly enhance the position of such competitors. Third, the disclosure of such information could reasonably be expected to interfere with our contractual or other negotiations with customers. In conclusion, we respectfully request that the committee maintain already recognized confidentiality of our commercial and technical information in the context of its audit. Thank you very much for your attention.
Thank you very much, Mr. Tada. Appreciate that. Turning now to Moderna. Madame Gauthier, you have the floor for 5 minutes, please.
Good afternoon, Mesdames, Messieurs, Président et membres du comité. Merci.
Thank you, Chair and members of the committee. My name is Patricia Gauthier, and I represent Moderna Canada. In November 2020, at the height of the pandemic, I was hired as Moderna Canada's first employee. Founded in 2010, Moderna was a small research-oriented biotechnology company that did research. Its mission was to deliver on the promise of mRNA science and create a new generation of transformative medicines for patients. We had no marketed product. At significant risk to our business survival, we made the bold choice to pivot all our focus towards playing a critical role in combating the COVID-19 pandemic globally. And we tried to implement new revolutionary new technology known as mRNA. Now globally known, mRNA was, at the time, a cutting-edge technology into which Moderna had invested over a decade of research. Because we had this platform, we were able to use it to create our vaccine in record time. It was our first product. Moderna had to amplify its operations on a global scale. I was receiving calls from government officials, members of parliament, provincial officials. I did not have staff. I worked with a small team globally.
Apply and ensure that we were responsive to the needs of the federal and provincial governments in Canada. Core to our ability to meet these extraordinary requests was the clear good faith balance between 2 key principles. The first was transparency to the government. The second was the protection of intellectual property and commercially confidential information. With these elements, Moderna could focus on vaccine production to meet these urgent needs. As we accelerated and partnered on our research, we also started building our manufacturing capacity in parallel. Now, 3 years on, our vaccine has been administered to nearly 1 billion people across the globe. It has played a vital role in helping us move towards an endemic world, which is vitally important given the pandemic has taken the lives of more than 51,000 Canadians. The Auditor's General report acknowledged the successful efforts of the Canadian government to secure a diversified supply of vaccine and therapies in this very intense period early in the pandemic. The Federal Cabinet, relevant departments, the Public Health Agency of Canada, and the Auditor General of Canada always have full access into our vaccine contracts at all time. We also understand that Parliament has full version of the contract redacted only for the intellectual property and commercially confidential information we have discussed. This is the same type of redacted documents provided to other parliaments globally. Mesdames et messieurs, j'aimerais en dire un peu plus sur l'importance.
Members of the committee, I would like to expand on the contextual importance of confidentiality as it relates to the biopharma model and its high-risk environment. 10 years before the pandemic, we invested billions of dollars in private funding to develop and test our innovative mRNA platform. Our investment into this platform and its intellectual property has been possible due to the rules supporting innovation and research. In 2023, we will invest $4.5 billion in R&D globally to continue transforming the future of medicine. To provide a context, this is about twice the pharmaceutical industry standard.
Relevant to our discussion today relating to securing intellectual property and the rule of law, which link to sensitivity of contracts with government. The first is domestic access to secure, safe manufacturing supply chains, and the second is linked to Canada's international trade commitments. By its very nature, biopharmaceutical intellectual property and its resulting supply chain are considered sensitive areas by governments globally. For Canada, this means that our innovation and supply chain are captured within the National Strategy for Critical Infrastructure and through the Government of Canada's biomanufacturing strategy. Many additional security, privacy, and safety protocols apply to our research, contracts, and supply chain. To ensure that neither the innovation nor our vaccines are compromised, our manufacturing methods and production supply chains are treated with the strictest confidence. The second important issue is related to Canadian international trade commitments. These commitments establish minimal protection globally, including patent and trade secrets. These protection encourages innovation. Canada has benefited from these multilateral international trade agreements. It's important that Canada respect these agreements continues. Moderna is invested in building in Canada's capacity and capabilities to play a key role in exploring the potential of mRNA technology for pandemic readiness and other scientific priorities, as well as onshoring manufacturing of vaccines here in Canada. Cette innovation ne pourrait avoir lieu sans les bases.
This innovation could not take place if it were not for the sound legal and regulatory foundations that exist here in Canada and made possible by legislators such as yourselves. The knowledge that the security of our contracts, the IP, and the supply chain details that are confidential are directly linked to how we operate globally. I look forward to answering your questions today and to continuing our constructive dialogue. Thank you. Mrs. Gauthier, next.
Floor for 5 minutes, please.
Good day, Mr. Chair, members of the committee. Bonjour. My name is Naja Sampson. I'm president of Pfizer Canada. Thank you for your invitation to share Pfizer's perspective on the motion before you. I'm here with my colleague, Fabienne Paquette, our mRNA vaccines and antiviral portfolio lead in Canada. She's joining us remotely. Today, I want to highlight why disclosure of our confidential agreements with the government sends a very concerning signal about how this country upholds its contractual obligations and could challenge its reputation as a reliable partner for future contracts across all business sectors. But first, I must tell you how proud Pfizer is of its partnership with the Canadian, provincial, and territorial governments in our fight against one of the most complex health challenges of our time. What was accomplished on behalf of Canadians was unprecedented and should be recognized as a model for collaboration moving forward. For our part, Pfizer has engaged in ongoing transparency with Canadian health officials and the public. Throughout the pandemic, we worked in lockstep with public health authorities and with Health Canada to share all data related to our vaccine as it became available. We regularly shared our timeline of manufacturing targets to help manage expectations and logistics. And as a result, public health authorities, health ministers, premiers, and the federal government have praised Pfizer's collaboration and the reliability of our contribution to the immunization campaign here. Independent analysis of the Canadian vaccine response to the pandemic has been overwhelmingly positive. The Canadian Medical Association Journal concluded that Canada performed better than most other G10 countries in terms of vaccination rates, infection rates, and mortality. The Auditor General examined all agreements related to COVID-19 vaccines, and this committee had the opportunity to question her and numerous officials about her findings. Her report highlighted several success factors, including the expedited process to authorize, procure, and distribute vaccines. The report also contains recommendations to make Canada's response to a future pandemic even more robust. Pfizer supports these recommendations and will continue to work with its partners in government on behalf of Canadians. However, nowhere in the Auditor General's report does she recommend further scrutiny, remain actively engaged with authorities around the world on the supply of our vaccines, and each country has its own requirements for supply. We stand by the obligations we have accepted in our commercial agreements with these stakeholders. These contracts contain commercially sensitive information that would likely be of interest to our competitors and also prejudice our discussions with other partners. We believe that proper and robust oversight of the vaccine procurement process, including parliamentary oversight, has occurred. Canada's response to the pandemic has been subject to public review by the country's highest auditor, and the AG fulfilled her commitment to Parliament and to Canadians. Pfizer's approach around the world is to maintain the confidentiality of the agreements for all of our medications, and our COVID-19 vaccine has been no different. Respectfully, I think it's fair to say disclosure of our confidential agreement would be an extraordinary use of authority. Contractual trust and stability remain a cornerstone for a country like Canada to attract investment and innovation. And although they aren't represented here today, we're quite sure that the Canadian government would agree with this principle. Eroding this predictability sends a concerning signal about how this country will uphold its contractual obligations, not just in healthcare, but across all industries. So, Mr. Chair, I ask members of this committee to take the time to carefully consider our perspective before creating a precedent with unintended consequences on Canada's reputation. It would send a strong message to business partners and to companies looking to invest here that here in Canada, confidentiality protections negotiated in good faith with the federal government may not be binding. Pfizer deeply values the level of cooperation with government throughout these unprecedented times, and we take very seriously the agreements that have governed this collaboration to date. We appreciate the opportunity to share our perspective and welcome any questions you may have. Thank you. Merci.
Thank you very much. I will note something just to get ahead of some of the questions that will come, so it doesn't continue to be an issue. It was referenced as well in some of the letters we received. The motion is to maintain these, the motion before this committee is to maintain these documents in camera. That is to keep them secret. So I will correct those that refer to this as being a public release of any sensitive documents. I just wanted to lay that out because it came up several times in several of the letters, and I thought it should be corrected. So I will now turn to our last witness who's presenting, Mr. Bellet from Sanofi. You have the floor for 5 minutes, s'il vous plaît. Pardon.
Monsieur le Président.
Mr. Chair, members of the Committee on Public Accounts. Hello, I'm Jean-Pierre Baillet, General Manager of the Vaccines Business Unit of Sanofi Canada. Sanofi is an innovative global healthcare company driven by a calling to pursue the miracles of science to improve people's lives. We develop treatments and vaccines that change the lives of patients around the world every day, including here in Canada, but also in the world's poorest countries. Sanofi has been firmly rooted in Canada for over a century. Over the decades, we've built one of the world's largest vaccine research and development and manufacturing facilities in Toronto on a 54-hectare campus. Today, Sanofi is on track to make more than $2 billion in investments in Canada by 2028. As Canada's largest vaccine manufacturer, Sanofi protects more than 7 million Canadians from infectious diseases each year and also exports to more than 60 countries around the world. We employ more than 2,000 people across Canada and help create thousands of related jobs in many sectors. We provide work-study opportunities to over 100 Canadian students each year. We invested $143 million in research and development in 2021, making us one of the top life science investors in the country. In the case of COVID-19, the partnership between the vaccine industry and public authorities has enabled Canada to achieve broad vaccine coverage, which has contributed to a reduction in hospitalizations and deaths. Sanofi has been one of the few companies to make its global manufacturing and supply network available to other companies so that they can accelerate access to their vaccines around the world. This commitment to addressing the urgent need for public health has recently led us to make one of the largest investments in the history of Canadian life sciences in partnership with federal, provincial, and municipal governments to strengthen manufacturing capacity and national preparedness in case of future pandemics. At Sanofi, we take the confidentiality of our business operations very seriously. This confidentiality is essential to our ability to pursue our investments in Canada or elsewhere. While we are committed to transparency, some of the information contained in the advance purchase agreement is highly commercially sensitive. For this reason, the agreement includes confidentiality obligations, which Sanofi expects to be respected. Strong intellectual property and trade secret laws are essential to fostering innovation and promoting long-term growth. The Auditor General's review and report on the COVID-19 vaccine contracts provides an objective and independent assessment within the law and without compromising commercial confidentiality. Disclosure of commercially sensitive information would set a serious precedent. In conclusion, Sanofi is committed to Canada and the health and well-being of its people every day. We want to continue to advance innovation in healthcare while respecting the confidentiality of our business operations and our ability to remain competitive in Canada or elsewhere. Thank you for your attention.
Et je vous remercie encore
Thank you once again.
from our members. The first four members will each have 6 minutes each. Dr. Ellis, you have the floor for 6 minutes, please.
Thank you very much, Chair, and thank you to all the witnesses for being here. And, I think it's interesting. Here we are 3 years later, and I can remember those early days of the pandemic very clearly when I was running a COVID unit back in northern Nova Scotia, and all of us were wondering if the world was going to end or not. And here we are 3 years later, and it doesn't seem a whole lot has changed, but many things have. To you, Mr. Tata, I'll start with you, if I might, sir. I just want to thank you, first of all, for being honest and wanting to agree to release information to this committee, if I heard you correctly. And certainly, I think the members of this committee want to be very clear in helping you and your colleagues here understand that this information is not for public release. So I'll reiterate that, as the chair said. So part of the question I have, you said you've agreed to release of some information. Does it make any sense? Why would you put intellectual property in an advance purchase agreement contract?
Thank you very much for the question. That, if I catch a question correctly, the question is why we have an intellectual property in the contract?
Correct.
By the way, interest correction is a product over many years of investment, but we did not prohibit in the contract for if the government wants to resell the vaccine, and if necessary, they have the licensing rights to use our intellectual property so that the vaccines for the pandemic preparedness can be produced domestically in Canada.
Oh, that's interesting, sir. So your company is leaving Canada, I think you said on the 2nd of June. Who owns that intellectual property then?
Medicago owns it currently.
Very good. And is it true, sir, that there's an advance purchase agreement with Medicago and the Canadian government for 20 million doses of your vaccine that was never, ever produced?
Yeah, because although we actually got an approval from Health Canada in last February last year, and we were preparing for the launch of the product, but we faced unexpected quality problem. And while we are fixing it, the market need for the vaccine evolved to the bivalent vaccines, although our vaccine is monovalent. Therefore, our approved vaccine is irrelevant because of the market involvement.
Very good, sir. And through you, Chair, is it also true that the WHO would not accept your product because of the involvement of Philip Morris with your company?
Yes, it is not because of the product quality or product itself, but because of our shareholding structure.
Very good, sir.
At that time.
Right. And through you, Chair, is it also true then, sir, that the Government of Canada invested $173 million into Medicago in terms of physical space and buildings and equipment, et cetera?
The contract we have, I said, was for development of the COVID-19 vaccine, as well as the building of the biopharmaceutical manufacturing capability in Quebec.
So, sir, through you, Chair, my understanding then, if even though we don't know for certain, if we're going to talk about $30 a dose, 20 million doses, $173 million that your company, without giving Canada a single dose, has received at least $773 million from the Government of Canada.
We use those. First, we appreciate all the support from federal government of Canada as well as Quebec government. And those funding was intended to finance our COVID-19 vaccine and the building of the manufacturing capacity in Quebec. And those objectives were actually fulfilled. We spent all those monies to fulfill the approval of the COVID-19 vaccines, and we have been proceeding the construction of the local manufacturing capacity until the recent decision made by our shareholder.
Right, sir. But again, to be clear, $773 million and no doses delivered.
Not really. When we were preparing the first launch, we faced a quality problem. We decided not to release out-of-specification product, certainly.
Okay, sir, but just to be clear, how many doses were given to the Canadian government to be distributed?
Is a contract?
How many did you actually physically distribute to the Canadian government? How many doses of your vaccine?
No dose was distributed from Medicago.
Okay, so no doses and $773 million, and Medicago owns the intellectual property and still owns the physical building and manufacturing capability even here in Canada.
Yep.
Wow, that's great. And in the contracts that you have signed with the Canadian government, if you could just clarify those things, because I wasn't sure what you were talking about in the very end, that it seemed you were talking about some redactation of those documents. Can you clarify that once again for me, please, sir?
The part that were redacted in our response to access to the information response in the February 2021 was relating to the information relating on pricing, quantity, and the facility locations and availability plans. We thought this has a direct commercial application. That is the reason why we requested a deduction of those documents.
About 20 seconds.
Sorry, did you say the pricing is redacted in those documents? Is that what you said?
Pricing and the facility locations and the quantities are the key information which should not be utilized by our competitors.
Okay, thank you, Chair.
Thank you.
Thank you very much. Ms. Shanahan, you have the floor for 6 minutes, please.
Merci beaucoup, Monsieur le Président. Puis j'aimerais.
Thank you. And I would like to thank our witnesses here with us today. Thank you for being available. And I'd also like to thank you, as my colleague has just said, thank you for your devoted work, especially during a period of time when no one in the world really knew what was going to happen early days of the pandemic. And I know that in Châteauguay-Lacolle, in my county, I remember we were watching on TV when we saw the first delivery of vaccines and the vaccination clinics started to open. It was very well organized in my riding, and we were so thrilled to be able to get a vaccine and then to continue being vaccinated. I'm not a healthcare expert, but I do understand that it's very important to save lives. So thank you so much for all this work. And the Auditor General produced a report on all this activity for public health and public services and procurement and how vaccines were procured. And I have it here in English.
And she found that the federal government had responded to the urgency of the coronavirus pandemic in 2020 and secured COVID-19 vaccine doses so that everyone in Canada who chose to be vaccinated could be. Vaccines were needed quickly to reduce the Canadians' risk of serious illness, hospitalization, and death from COVID-19. And the Auditor General herself was quoted as saying, in 2020, Public Services and Procurement Canada established advance purchase agreements with 7 companies that showed potential to develop viable vaccines. Signing advance purchase agreements increased the chances that the government would obtain enough doses to meet Canada's needs. Recognizing this approach brought the possibility that Canada would have a surplus of doses if all vaccines were eventually approved. And that's what this committee is about. It's about looking at, once a policy or an approach is adopted by the government, what were how was the implementation carried out, and were the outcomes achieved? And I'm sure that the witnesses are aware, and of course, in the same time, that the Auditor General has all the tools that she needs to do her job. So as the witnesses are aware, we heard further testimony from the Auditor General, as well as Public Health and Public Services and Procurement Canada in February of this year regarding these findings, including issues around surplus vaccines and data sharing between different levels of government. During this meeting, the AG said in response to a question about access to confidential documents, yes, we had access to all the contracts, all the information, all the corrections, and all the amendments, confirming to members that access to documents was not a problem in her audit work. Now, we are all aware that we're here today because we have a request to have access to unredacted vaccine contracts between your companies and our government. Because apparently, according to various media reports, elected representatives in other countries have had this access. So I'd like to ask each one of you in turn, can you provide our committee with an update on the level of disclosures that your companies have provided to other countries for their vaccine contracts? And perhaps I can start with Madame Gauthier.
Merci beaucoup pour votre question.
Thank you for your question.
Has consistently provided redacted versions of agreement when requested to parliaments. No unredacted versions of agreements have been provided to parliaments in the world, and this has been a consistent position that has been taken by the company. Merci.
Thank you for the question. Similarly, Pfizer's position is not to provide unredacted contracts, and we have not done so across the globe.
Merci de votre question, Madame Shannon. À notre connaissance,
To our knowledge, only redacted versions have been made public by Sanofi in other countries.
Pouvez-vous répéter encore?
oui.
Could you repeat that? Yes. To our knowledge, at Sanofi, only redacted versions I don't know the word caviardé. It means redacted.
In French.
Non, non, c'est bon.
It's not a word we use every day.
C'est vrai, c'est vrai. Excellent.
Seules des versions caviardées ont
Only redacted versions were made public by Sanofi in other countries.
Companies provided completely unredacted vaccine. Oh, I'm sorry, I forgot the gentleman from Medicago, but of course you've already agreed to provide unredacted
by the way, for the
content. Yes.
contracted only with Canada and no other country.
Il vous reste 20 secondes.
Have any of your companies, what is this that we're hearing about other countries, such as Brazil and Colombia and so on? I don't have much time. I think colleagues will pick up on that. But how did these
We'll have to leave that
contracts
in suspension, but I'm sure, Ms. Shannon, we'll be coming back to that important question. Madame Saint-Clair-Desgagnés, vous avez la parole pour 6 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you. First of all, I'd like to thank the witnesses who are here with us today, and also those here virtually. I think it's important for the person who tabled the motion to clarify something. You're not in hostile territory before this committee. I think it's important to set the context, and also to reaffirm to what extent we are grateful towards pharmaceutical companies for their work during the pandemic. You've done something exceptional here. In this context, exceptional measures were adopted by the government, and now I'd like to remind us that also then there's accountability, and this is part of our work. And it's within this context that we have undertaken a follow-up with the Auditor General, who confirmed to us that she was unable to answer questions with regards to contracts with pharma companies because she was constrained by the law to do our work as parliamentarians, as was done in other committees, in other circumstances. In the past, we requested to have access to these contracts in camera, and Mr. Chair reaffirmed this. We took necessary precautions so that this information, this confidential information, would remain confidential. And I think that there seems to be a confusion on the role of parliamentarians and privilege of parliamentarians. Perhaps there's a lack of knowledge of the case law. Also, there's the Access to Information Act in Canada. That's something different. This committee is the first step. We have been sensitive to a confidential nature of contracts. There are other recourses that exist to have access to information, and I would like to highlight that we don't want to find ourselves before the courts because case law would be on our side in any case. So we are in a constructive process. We simply want to make sure that there was no abuse, major abuse, that there was no mistake, and to, if there were mistakes made, that we can learn from these mistakes so that in the future, if we go through a similar pandemic or another pandemic, that we would be able to not commit the same mistakes, and we would be able to set out fair contracts, etc. I'm not sure if you had access to the response of our law clerk, and who reminded what in camera means. And also, there's an important example that I'd like to mention. There were many cases where committees can ask to have access to confidential documents. We've had cases in the past where the government did not want to disclose documents, and it was ordered. Another important case to mention is that, unfortunately, AstraZeneca is not here, but in 2005, through access to information, a competitor asked to have access to information in a contract, and the federal court judge indicated that only in company secrets, industrial secrets, and we have to see the difference between commercial secrets and industrial secrets. So only industrial secrets linked to procedure and manufacturing should be redacted. Commercial information is excluded and is not found in the exclusions of the Access to Information Act. And also, I'd like to take the time to mention and also to answer to the concerns that have been raised in many letters that we've seen, either by chambers of commerce or pharmaceutical companies, or even here in some opening statements, a fear of a very difficult business climate. And I believe that there's an exaggeration as to potential impacts. Here, we're not talking about making anything public, and there's been no deterioration of the business climate. When AstraZeneca's contract was made public, there was no deterioration. They're investing $500 million in Canada, and many people in the pharmaceutical industry agree to say that in Canada and in Quebec, we have life sciences sector that is quite vibrant, and there is a very healthy business climate. This would not create a dangerous precedent, and I would like to reiterate that we're operating in a constructive way. For accountability purposes, it's very important, and this is important because the more 30 seconds. So the more tension that we will have, the more suspicions will increase, and that's not what we're trying to do. We want to work with you in a spirit of collaboration in order to avoid that confidence in our institutions and pharmaceutical companies would degrade. And I believe it's important to raise that. And that's time.
Mr.
I didn't want to interrupt the colleague, but now that she's finished the first part of her questioning, I just want clarification. I think that a staff member handed... Okay.
Yes. So, Madame Secrétaire d'État, dans le futur, lorsqu'il y a...
In the future, when we have documents for our witnesses, no, I understand, but in the future, it has to go through the clerk to make sure that it's in both official languages. That's the case.
Your point is well taken. All documents need to come through the clerk before they are passed on to witnesses. In this case, it was just the motion. I appreciate that, but we do want to make sure that we're operating so we're all aware of what's being passed to witnesses. I appreciate your restraint on that, Mr. Fragascatos, as well. Next, Mr. Desjardins, you have the floor for 6 minutes, please.
Thank you very much, Mr. Chair, and I too want to thank the representatives from several companies who are present with us today. I do want to make, for the record, important reading into the record an important absence of AstraZeneca Canada, who's not present here today. I think that is something that Canadians do deserve, as a matter of fact, to have these individuals who are doing business in our country, and particularly on something so serious, to be present for accountability. So I do want to mention how disappointed I am in that fact, and how pleased I am to see that there are representatives willing in this country to participate in our public institutions in a way that can build confidence for Canadians, because that is what we're doing here today, and that is the work of public accounts, and that's the work that parliamentarians are tasked with. And so I hope you can sympathize beyond your own confidentiality purposes, or purposes to secure confidentiality, that our purpose here is to ensure that the proper amount of light is shed onto these kinds of things that can ensure we both can achieve our means. The public scrutiny that's required on behalf of parliamentarians, and of course the work you folks have in running the operations of your business. And so I do want to make specific mention as well to the fact that this was an extraordinary circumstance. I do acknowledge that fact. This is a once in 100 years pandemic, and it required swift and immediate action by the government. Something that New Democrats called for, something that many members of the opposition called for. So I also want to recognize that important fact. Two, I want to recognize the fact that several companies, and many of them who are present here today, also acted swiftly to ensure that the needs of Canadians, particularly the production of vaccines that are quality, to ensure that Canadians were protected. And so the matter of science is quite ingenious in many ways. So thank you to your scientists and to the many good doctors and researchers who made these life-saving miracle vaccines possible for Canadians to enjoy the moments that we're having right now, to return to our duties in Parliament, for example, is one of the very things I'm proud that vaccines have been able to achieve for us. I do want, however, distinguish between my comments in relation to the advent and importance of science in Canada and the difference between science and corporations. You know, corporations are a different entity in Canada, and corporations should not be seen to have any extraordinary powers in the sense that they could circumnavigate the will of the public, in particular the will of governments and the will of our Parliament. And so I'm really happy to see the law clerk present here today, and I want to thank the law clerk for your letter describing what is important to this committee and how we can actually ensure that we can utilize our powers here to do both. One, ensure that we can have accountability and light shed on the work that we're doing, while simultaneously protecting the confidentiality of these companies. And maybe I can ask the law clerk to clarify in his letter, or maybe even to repeat, how the process that is moved by the motion from my honourable colleague is in fact a process of confidentiality that has been taken by committees and has in fact demonstrated confidentiality in other cases. Could you comment on the efficacy, the efficiency and efficacy of that process and the comments that you made in the letter?
Well, as you indicated, the committees have the power to send for records and papers, and this power is absolute. But that said, once concerns are raised respecting the confidentiality or sensitive nature of documents, the committee, of course, can put measures in place with the view to protect the confidentiality of the information. There are a variety of means that have been used in the past by committees. Now, the motion moved by Ms. Sinclair-Degagné will make sure that the documents are consulted by members only under the supervision of the clerk without any cell phone or any other electronic device, and that when the committee considers these documents, they are considered at in-camera meeting.
Thank you very much for that, law clerk. And so my question is to the members now. In relation to what you've heard in terms of the powers of Parliament in order to ensure that these things are, and we deal with serious issues here, not beyond the seriousness of COVID, but also issues of national security. And these have been processes that we've undertaken before to ensure the protection of national security information. And so it becomes a matter of, do you not trust our Parliament in many ways? And so it's important that Canadians understand that we're having a relationship with corporations that should in fact be able to comply with the rules and regulations in Canada, but also to comply with the democratic process. And so my question directly, and I'll follow up in some subsequent rounds, is I want to make mention, I'm very pleased to hear the member from Medicago willing to release that information. I think that's important to our process, and your willingness demonstrates your ability and knowledge of our system. And so to the other members, are you not confident in the processes that we utilize in this place in order to ensure that we have confidentiality means protected? Maybe we'll go through all the present members first.
You got about a minute.
It could be yes or no.
Sorry, is my okay. Je respecte votre position.
I respect your position, and I maintain that Sanofi does not wish to disclose information in the contract, that it be disclosed within this committee. We believe it's a question of balance between a need for transparency and a need to respect confidentiality of contracts.
There. And so either you're not recognizing those confidentiality aspects or you don't want to do it.
Nous estimons que
We believe that the role and the mission of the Auditor General of Canada and her office.
I'm asking about Parliament.
il me semble, et j'ai lu.
It seems to me, and I looked over the website of the Auditor General of Canada.
Actually, Mr. Digely, you're out of time, but why don't we let him finish because you are out of time.
Sure,
so
if you
yes.
can find it.
Je pense donc.
So I wanted to say that she is mandated by the Parliament, and for Sanofi, we were transparent and we provided the information that we thought it was necessary to provide. Thank you. Thank you.
Sorry, Mr. Digely. Sometimes you were right on the money, but I figure it was best to get an answer before moving on. So okay. Commencing now our second round for 5 minutes. Mr. McCauley, you have the floor, please.
Thanks, Chair. If I could work the microphone. Witnesses, thanks for joining us today. Quick question. Say Pfizer, have you released anywhere in the world access to the documents to elected officials in committee or otherwise?
Thank you for the question. Pfizer has not.
Okay. Let me just ask you, Mr. Desley covered it, as did, I can't remember last name, but my friend from the block. Sorry, I can't call your last name. Sinclair Dejanay. We are not asking for these documents to be released. They're going to be held in a separate room for us to view without access to any ability to take pictures or document this. I'm looking at the letters sent to us, to the committee, from the American Chamber of Commerce in Canada, the Canadian Chamber, Biotech, Montreal Chamber, Innovative Medicines Canada. All wrote letters to the committee implying that we were going to publish these or disclose these letters. Did Pfizer, did any of you contact these organizations and ask them to contact the committee with what appears to be very misleading information?
Thank you for the question. We work very closely with some of these entities.
Sorry, I didn't ask if you work closely. I just asked, did you contact and ask them to write the committee?
We have been in contact. We have not asked anyone to write specifically about this. I think what we're seeing is just...
The reason I ask that is we're not asking to publish these. We're not asking to disclose these. It's to be in a secure location, as Mr. Bedard indicated. I'm just curious, like how many in Canada, for example, or perhaps the US, UK, the EU, procurement officials would have had access to these contracts? Just ballparkish.
I would say in every market where we were working with procurement to sign these contracts, they would have had access.
Ballpark, how many people? 500?
I'm not sure. But
a fair amount.
I can get back to the clerk on this.
Like I've seen contracts that have been leaked, Albania, Brazil, Colombia, Chile, the DR, the European Commission, Peru, USA, UK. Do you have any evidence that shows that those leaked contracts came from politicians or elected officials?
I'm not familiar with all of those instances, but I do know there have been a couple of leaks.
Is there any reason to believe they came from elected
right
officials?
Away. I'm not exactly sure if we know who leaked the information, but Pfizer, in these cases, never voluntarily provided an unredacted contract.
Do you believe that any of these leaks came from elected officials?
I can't answer that, I'm sorry.
Were there any commercial repercussions to these countries in these leaks? Because I've listened to your testimony, I've seen the letters, and they're very implied threats to investment in Canada, et cetera, if 11 MPs in a private room have access. So all these countries with leaked contracts, and I've got many of them here with me, were there divestment in these countries, similar to what seemed to be implied if the 11 MPs in the room looked at the contracts?
I don't think in any of these cases, I'll speak on Pfizer's behalf, we ever implied that we would divest if a contract was leaked.
The conversations we've had and what letters sent by your advocates have stated very clearly investment is at risk in our country, and yet where they've leaked full contracts, you haven't divested. So it seems like an odd implied threat if 11 MPs were to look at it with zero ability to get these items out would be a threat to investment and development of the pharma industry in Canada, and yet fully leaking the EC one, for example, has
30
no
seconds.
repercussion. Okay. Curious, are all of the contracts, and I'll open to each of you, do each of you state that it requires the permission of the pharma to release the details of the contract, that each department or each country, Canada, US, requires permission from Pfizer, Moderna to release the contracts or details?
These are two-way contracts signed by both us as well as the Department of Procurement. It is our intent that these are always confidential, and we remain confidentiality throughout.
Thank you very much. Ms. Bradford, you have the floor for 5 minutes, please.
Thank you, Mr. Chair, and thank you to our witnesses for appearing today. And thank you for all the research that your companies did to keep Canadians safe and safe from the worst effects of COVID-19. So I just want to get back to MP Shanahan's question. This is for you, Sanofi. I just want to clarify. So you said that there hadn't been any unredacted release to the public. I think the question was about to parliamentarians. So was there any unredacted to any parliamentarians anywhere?
À ma connaissance,
To my knowledge, there has been no communication of an unredacted version to a parliament in any other country in the world. But if you'll allow me, I can check with our legal team and come back to you on this.
Thank you so much. So just to each of you now, so just to confirm, your companies have not provided unredacted contracts to the European Union, the United States, United Kingdom, Brazil, Colombia, Australia, or anywhere else. You haven't provided unredacted to anywhere. I see head shake there.
So Moderna has not provided unredacted contracts to any parliaments globally. It's been a standard position. Thank you.
Okay.
Same with Pfizer.
Okay. Sanofi? I think you just said that, right? And I'm not sure that, Joe, you haven't produced it to anywhere else so far, have you, or have you? Unredacted?
Medical contracted only with Canada, with no other countries.
Okay. So now I'm going to go down the line again, too. Could you describe the sensitivity of the information in the contracts like these? If Ms. Gauthier, would you like to start?
Yes, absolutely. Thank you very much for your question. And maybe I'll just take a step back a little bit and talk about the context in which these contracts were negotiated. And it's been talked about. It was full-on peak of the pandemic. It was urgency. We didn't have products at the time yet. And it's really important to think about that because the confidentiality, the assurances, the security that were provided through these agreements were really, for us at Moderna, what allowed us to move very quickly, to collaborate swiftly with the government, to create a place to co-create, actually, and then to really enable us to focus on increasing the speed of our development of our vaccine, which was developed in less than 12 months, and also to ramp up our manufacturing globally. We had never made products commercially in the world. So that safeguard was really important in allowing us to move quickly. And there are many types of information that are very sensitive in these agreements, from processes to commercial information to know-how. So there's a variety of information that is highly sensitive and confidential, and that from a global perspective as well, and in a competitive market environment. Thank you.
Sampson?
Maybe just to add a bit to that, because I think these contracts contain proprietary and commercially sensitive information for all companies. But I think, when we take a look at where we were when we originally signed those contracts and where we are today, I mean, it's easy to say that, we're past the pandemic, but we're actually still managing. So even today, we are working with countries around the world for supply to vaccine. So those same sensitivities that existed 2 years ago are in play right now. I would say, in addition, there are things that are confidential to the country that we're working with. So the other signatory on the agreement, there are things around supply schedule, delivery, and other support that we're providing to that market.
45 seconds, Ms. Bradford.
Mr. Bellet?
Question. Sanofi n'a conclu cette entente qu'au terme d'un processus concurrentiel.
Sanofi concluded this agreement after a rigorous competitive process. The disclosure of the information in this contract could put us in a difficult position. The pandemic continues. Other negotiations are underway in other countries. And so we do not want the information in the contracts to be made public.
I understand. Thank you. That's my time.
That's pretty much about it. You've got a
Okay.
few questions for a few seconds for comments, but I think I just ate them up unless you want 10 seconds. So no, I don't want to take your time. So, okay. Et Madame Sécla Desgagnés, à 2 minutes 30 secondes, s'il vous plaît.
Merci, Monsieur.
Thank you, Mr. Chair. There's an interesting case that was raised by a new member of the OECD, Colombia, where an administrative tribunal determined that the right to access to information had primacy over the commercial interests of pharma companies. And I have the information here that it was, if we ask the pharmaceutical companies if they disclose the contracts, they'll say no, because it's the Council of the State that disclosed. And this was on August the 10th, 2021. So we do have some unredacted contracts. We have other redacted contracts. And I think that the scope of the redaction depends. We have a lot of information on prices in other countries. Some countries were mentioned by my conservative colleague. And so a lot of information is already available, and I think that the crux of the issue is a lack of understanding of our parliamentary role here. The work that we're doing, I think that it's really important that we rectify the role of the Public Accounts Committee, which is to report on the reports of the Auditor General. And it is within that context, when we were studying the AG report, that we made this motion. We tabled this motion to obtain the information according to the act of the Auditor General's office. She could not provide it to us. She sent us a letter to say, unfortunately, if you want to have access to that information, you yourself have to have access to the contract. I cannot respond. She was very clear on this. So it was a type of invitation to look at the contracts. And once again, to demonstrate good faith, we have no intention of making this public. We just want to do our work as parliamentarians. So this is important to note. I'd like to hear Mr. Bellet speak to this. Now that I've brought forth these specifications, have you changed your mind? Or does this make our role any more clear? Thank you for your question. I have not changed my mind. I respect your opinion. Yes, Owen, I'm steadfast.
Mr. Desjardins, you have the floor for 2.5 minutes.
Thank you very much, Mr. Chair. And so, hearing from several members of our committee now, you can see there's a few disputes. One is on the nature of what you believe Parliament's role is, and one is what we believe your role is. And I'll clarify my position on this clearly, which is that I do believe that Canadians do deserve the kind of transparency democratic government and a free society would expect from those who are operating commercially in Canada. I was disappointed to hear Jean-Pierre Ballet's comments, and I won't return now. I believe your position is well noted in the record that you oppose the perspective that this committee would, in fact, have some role of breaching your perception of confidentiality, given the fact that we've offered you a confidential process that would actually guarantee that. And it's sufficient for all other means, particularly national security means, but apparently it's not good enough for you, which is a big problem for Canadians. And I'll make that note known in our report, and something that I'll hopefully make mention to the government as well. To the other members, what do you believe in? Is it your perspective that the confidential process of Canada's Parliament is insufficient for the purposes of reviewing your contracts confidentially in a confidential way? To the other members.
For the context and also for the question, I believe that even viewing in camera would be a breach of the confidentiality clauses that are put forward in our current contract with the Department of Procurement.
So thank you very much for the question. We have not globally in any countries provided unredacted copies of the agreements to parliaments. That has been a position. And as my colleague said, there are very strict confidentiality clauses in the agreement that would put us at breach should we go outside of what is provided in these agreements and share these agreements in a non-redacted manner.
Ms. Gauthier, you mentioned in your last remarks that you co-created this with Canadians, but apparently Canadians can't co-own it. And so this is a perspective of an issue that you can see is a problem when we're talking or dealing with public financing. I don't have enough question now to speak to my question on how much public finance each of you have received from Canadians, but that'll be the question I will follow up with in my next round. So I'd hope you'd have that information present. And if you don't have it present, to make it readily available in written format.
Thank you very much, Mr. Desjardins. Mr. Cram, you have the floor for 5 minutes.
Okay, thank you, Mr. Chair, and thank you to the pharmaceutical companies for being here today. Ms. Sampson, in your opening statement, you said that you believe that parliamentary oversight has already occurred. Could you explain how that's possible, given that parliamentarians haven't seen the contracts yet?
I'll refer back to the Auditor General's report, which I thought was a thorough review. Taking that into account, the fact that the Auditor General herself has been in front of the committee and questions have been asked, I do believe that there has been a solid level of oversight provided into the vaccines process.
Why were you willing to provide the contracts to the Auditor General but not to a parliamentary committee?
Speaking for Pfizer, we were not a part of the process that supported the Auditor General's report.
I'm sorry, so you did or did not provide the contracts to the Auditor General?
We did not.
Okay, so could you explain how the Auditor General came to the conclusion that everything was fine and good with the procurement process?
I believe that the Auditor General did have a copy of the contract. It was not provided by Pfizer.
It came from the
so it was simply,
Mr. Cram, it came from the government of Canada.
Yes, okay,
Yeah,
understood,
sorry, yeah.
understood. Okay, so let's say, okay, so why is it okay for the government of Canada to provide the contract but not the pharmaceutical companies?
I think I'm here providing my perspective, and if there was a question of whether I thought that the contract should be provided, my answer would have been the same. I do not believe that the unredacted contract should have been provided. I believe that providing it constitutes a potential breach of confidentiality as laid out in the contract.
If the contracts ever became the subject of a court case and there was a court order to provide the contracts, would you listen to the judge and provide the contracts, or would you ignore the order from the judge?
I don't know if I can speak about legal consequences like that, but that would never be my option to ignore a judge's request.
So then why is it okay to ignore the request from a parliamentary committee?
I think I'm just here providing our perspective on the confidentiality of these contracts. We have not provided these contracts to parliaments anywhere around the world in an unredacted manner, and we would want to maintain that level of confidentiality as possible.
Do you feel that the pharmaceutical companies are above the law?
Absolutely not.
So then why can't you comply with the order to produce the documents?
And this is just our perspective. At Pfizer, we have not provided an unredacted contract. We do believe, however, looking at the Auditor General's report, that with the access that they had, they have provided a solid overview of what happened during the pandemic with regards to vaccine providers. And I think that level of oversight has happened.
Mr. Chair, how am I doing for time?
You've got about 1 minute, 10 seconds.
Okay. So parliamentary committees deal with sensitive matters all the time. Like during the war in Afghanistan, there were studies about the Afghan prisoner detainee situation, and that dealt with movement of troops in Afghanistan during the procurement of the F-35 fighter jets. Parliamentarians had access to highly sensitive military documents. What is it about the vaccine contracts that makes them so much more sensitive than troop movements in Afghanistan or new fighter jets?
I don't want to compare this contract to any other. I think in this particular case, we are still working with countries around the world to supply vaccine. There are commercially sensitive pieces within that document, within that contract, as well as proprietary information. And I think what I am saying is that Pfizer hasn't provided that contract unredacted anywhere around the world voluntarily, and that's not a precedent that we believe needs to be set here in Canada.
Thank you very much. That is the time. Ms. Yip, you have the floor for 5 minutes, please.
Thank you. In my riding of Scarborough Agincourt, we have a lot of seniors and long-term care homes and families. And I would just like to say thank you very much. We are most thankful. I also have a hospital, part of the Scarborough Health Network, Birchmount Hospital, where we have vaccine clinics. So just to be able to have choice and the available supply, I'm very thankful. What contract risks are there in disclosing intellectual property? If each one of you could provide an answer, that would be great. Thank you.
Attends une seconde. Oui.
Pourriez répéter, s'il vous plaît?
Could you repeat, please? I didn't hear the question.
What contract risks are there in disclosing intellectual property?
Merci, madame.
Thank you very much for your question. So, and I'll speak from the perspective of Moderna. I mean, we are about 13 years old today, which is pretty, even pre-teenage years. And we've been investing in research and development for 13 years. The investment we've made in our mRNA platform has enabled us to be able to respond very quickly during the pandemic and bring a vaccine to Canadians on December 24th, 2020. And our vaccine was even able to reach, places like Scarborough, but also Yukon, Northwest Territories, and other more remote areas, and protect the Indigenous communities and other more remote communities. So this is the fruit of significant investment in research and development. This is the result of significant investment in innovation, and we must protect that innovation so that we can actually continue protecting the life of patients like those of Canada. And that's where protecting intellectual property is absolutely critical, so that we can continue, not just us investing in research and development, but all other members and companies in the life science ecosystem can continue, and then we can create a really strong innovation and life science ecosystem. This is really important. It's important in the academic setting. It's important in the pharma industry. IP, or intellectual property, is really the key piece that we create so that we can have significant benefits for patients and save the lives of people like here in Canada, as we did during the pandemic.
Yes, I think that any pharmaceutical manufacturer that has invested in R&D absolutely believes in the power of IP protections to ensure that innovation can continue. I will speak, just on behalf of Pfizer. We moved incredibly quickly during the pandemic to ensure that we were meeting the needs of people here in Canada and globally as quickly as possible. The IP protections that have been provided helped us do that without question. I think without those, you wouldn't have seen the level of cooperation between companies. It would have been impossible for a company like Pfizer to scale up to the level that we were by working with so many other contractors and manufacturers around the world to ensure that the supply of vaccine required, the global supply of vaccine required to meet the needs noted during the pandemic were met.
This would actually hurt collaboration with other companies.
Absolutely. I think one of the cornerstones of innovation is being able to not just look inside of your company, is to be able to see how best to both research and develop and manufacture a vaccine or a medicine. And sometimes that IP exists with another partner. Having those protections protects the collaboration.
Thank you. Mr. Baylet, please.
La protection de notre propriété.
The protection of our IP allows us to operate in a secure way in Canada. It's very important to secure the future of jobs, investment. I think this is at the heart of our discussion, is to make sure that this confidentiality remains intact.
Just, Ms. Yip, I'll stop the clock. You have about 15 seconds left. Do you want to hear from Mr. Tada, or you?
We'll go to Mr. Tada.
Yeah,
Thank you for that.
Yeah, okay.
Mr.
Thank
Tada?
you very much. Thank you very much. As my colleagues mentioned, R&D or innovation is a fruit or central part of the pharmaceutical industry. It's a result of the many years and many dollars of investment and for the innovation. So this can be one of the most important assets for the pharmaceutical company. Thank you.
Thank you very much. That is the time. Mr. Genuis, you have this is our third round starting. Mr. Genuis, you have the floor for 5 minutes, please.
Thank you, Chair. So much about this situation, frankly, is just mind-boggling to me. We have one of the chief accountability committees in Parliament that is asking for vaccine contracts related to the COVID-19 vaccine. We are not asking for it for public release. We are asking for it so that the small group of members of Parliament who have been charged with holding the government accountable in these areas can privately review these documents and provide recommendations to the government. That is all we're asking for. The information which many public servants have should be available to this committee, because their function is implementation of the government's directives. But our function as a committee is accountability, is review and to provide those recommendations. So the government and pharmaceutical companies who are here today are happy to have the implementers, the public servants who don't have that same accountability challenge function. They're happy for them to have the documents, which is in some more people, but you're not willing to let us have access to the documents. And it's important to just underline that in our system, we have the supremacy of Parliament, which means that Parliament is the supreme lawmaking body. And that doesn't seem to be understood by the witnesses very well, that we have an unfettered, constitutionally protected right to request documents. This has been recognized for over 100 years by multiple speakers, as recently as by Speaker Rhoda. That it's not a question of us engaging in some kind of negotiation, like we're going to ask really politely and we're going to let you eat some of the cookies at the back and then maybe you'll give us a little more information in the documents. We have a right to access this information as a parliamentary committee, and we have an obligation to use this information responsibly.
Mr. Genuis, I appreciate it. I'm hearing a point of order.
I'm just thinking technical, and for the interpreters, Mr. Genuis is speaking very loudly into a microphone.
Mr. Genuis, if you can continue your line of questioning. I recognize you generally have two sleeps, or you have two settings, sleep and awake. But if yes, I suppose. Look, in all seriousness, this is Mr. Genuis's time. He's welcome to ask these questions any way he sees fit. But given the fact that we do have translations and concerns about hearing, I would ask that you just be aware of that. And I ask you to proceed as well. And I've stopped the clock, and I'm going to start it again. You have 3 minutes and 22 seconds remaining.
Thank you, Chair. This situation is outrageous, and we can have some levity in passing, but I'm extremely frustrated by it, that we have witnesses who don't understand how the law works, who don't understand the fact that a parliamentary committee is unfettered in its right to access documents. And we should use that power responsibly. We will use that power responsibly. We are not seeking these documents for public release. We are saying that these members of this committee should be able to privately access this information so that we can provide information to the government. And and yet the government is unwilling to provide these contracts, and you are opposing the provision of these contracts. And it makes me wonder what in it is so damaging to you or to the government that allowing members of parliament to privately review them would be such a concern. Now, I want to particularly highlight that Speaker Anthony Rota made a ruling at the end of the last parliament that reaffirmed 100 years of precedent, saying that parliamentary committees have an unfettered right to access documents. Do you recognize the authority of the Speaker to make that ruling? And do you believe that the government and that companies should comply with the law in this respect? And I'll take a short answer from all of the witnesses. Do you recognize the authority of the Speaker to make this ruling and the obligation of the government and of companies to comply with the law? We'll start with Mr. Baylet.
Sanofi.
Sanofi recognizes the obligation
that we have to respect laws, and we respect laws wherever we operate. As far as the competency of that committee to review a unredacted version of the contract of Sanofi, I cannot answer that question.
So you don't think we're competent, but you accept the Speaker's ruling and the obligation to provide?
I would not judge.
Okay, well, Ms. Sampson.
That's not what I said. Thank you.
Okay, well, I don't know what you said, but I only have so much time. Ms. Sampson, do you recognize the Speaker's ruling and your obligation to comply with the law?
I understand the direction that this committee would like to take, and I am not refuting any of the authorities that have been placed with this committee, but it is still Pfizer's position that we not provide an unredacted contract.
So again, not really an answer.
45 seconds.
Big Pharma is not supposed to be above the law, and we need these contracts. Ms. Gauthier, what's your position on the Speaker's ruling?
Yeah, so I mean, we will comply. We comply with the laws in every country where we operate.
Okay.
We will always continue.
And that includes an order of a parliamentary committee.
We will comply with the law
Thank
in
you.
every country
Thank you.
where we operate.
The gentleman from Medicago. You've already said you provide the unredacted documents. I hope that the government doesn't continue to try to cover for the desire of some industry to hide these contracts. I want to also just ask, who asked for the confidentiality contracts? Was it a demand from industry in these negotiations, or was it a request from the government?
Mr. Jennings, we'll have to come back to that, I'm afraid. You're out of time, but there will be a subsequent round. Turning now to Mr. Housefather. You have the floor for 5 minutes. Good to see you back, sir.
Thank you very much, Mr. Chair. Thank you, colleagues, and thank you for being here today, all of you. I want to start by clarifying a few things. Number one, nobody in this motion from Mesdames de Saint-Clair de Gagné doesn't ask the pharmaceutical companies to provide anything. It asks the government to provide something to the committee. So right away, the questions about whether you've provided or not provided are not the relevant questions. The question is whether or not in any other country, a government has provided to a parliamentary committee these contracts. So just yes or no, Madame Gauthier, has in any other country a government provided to a parliamentary committee a Moderna contract?
Thank you very much for your question. To my knowledge, no.
Ms. Sampson?
To my knowledge, no.
And
À ma connaissance, non.
To my knowledge, no.
the question that I want to then get at is there's an allegation that there would be breach of the contract. Because I come back to what Mr. McCauley said. There's civil servants that have gotten these contracts and have read the contracts unredacted. The government of Canada has said we will waive the redactions that we requested that in previous parliamentary committees. So there will be no redactions at the request of the government. So the question is, would the government be in breach of our contract with Moderna, Pfizer, and Sanofi and others in the event that we provided the contracts in an unredacted way and the company said that certain provisions of the contract needed to be redacted for trade secret or other reasons? The standard, I haven't seen this contract, but I've seen the released Pfizer contracts that have been leaked from other countries. In all of those countries, there's a pretty standard provision in the confidentiality provisions that says an exception to the confidentiality provisions are when, as a matter of law, the contract needs to be disclosed. In Canada, there's the Parliament of Canada Act, which is a law which allows a parliamentary committee to compel the release of the document. So can I understand if this, which I assume is the case, because I was the general counsel, like Madame Gauthier, I have the legal experience. in the past, when I've ever had a confidentiality clause in an agreement, which is the standard, Mr. Genis, it's in all agreements and both sides want it, there's an exception for providing it if a law requires it. And then the normal thing is then the disclosure has to give the opportunity to the recipient, the other party, to seek a protective order and cooperate. These are the standard clauses. So if this is the standard clause, how would the government then be in breach provided we gave you notice and helped you seek a protective order or agreed to cooperate to help you seek a protective order? I think Madame Gauthier would probably be the best place to answer that question.
I have not practiced law for many, many years, so I will not comment on the legal aspects of this, if I may. It's a really good question, and I think what we want at the end of the day is that the terms and conditions that are contained in these agreements remain confidential. That's what we want ultimately. And it's important because, again, put yourself back in context. 2.5 years ago, crazy times. We had to move fast. We had to create together. We created these agreements. And I think what's important for companies, and I'll speak for, I come from a big pharma. I'm in a tiny biotech that is going fast, that is investing in Laval, will be hiring more Canadians, will be developing Canada into a center of excellence in mRNA. That's massive. And that's because we believe that Canada offers a predictable, secure, and stable environment in which we can do business.
Absolutely. You deserve predictability. The question is, every company that enters into an agreement with the Government of Canada knows that it's possible that parliamentarians may ask for a copy of the contract. It's happened right now with McKinsey before the OGO committee. It's not unheard of, and there's a confidentiality process that can be. So what I want to now get at, Mr. Chair, how much time do I have left?
About a minute.
If in this and whatever subsequent time I have in another round, I want to understand precisely, explicitly, not just saying there's secret stuff in the contract. I want to know what clauses in the contract you would consider confidential. For example, in the event that the formula for any of the vaccines was included in an annex to an agreement, which would be highly unusual because I don't know why Canada would need to produce it because we wouldn't create it ourselves. That, to me, I could fully understand why the committee would have absolutely no need to know the formula you made of the vaccine. So in my next round, I'm going to ask you and think about it, specifically which clauses in the contract you think need to be withheld and why, okay? Thank you.
You still have about 30 seconds if you want to at least get one answer.
I guess, Madame Gauthier, can you, again, 30 seconds, try to answer which clauses?
So there are global dynamics at play here. When these agreements were negotiated, again, every country was trying to secure supply of vaccines for their country. And there are dynamics in terms of price referencing from one country to another, each circumstances of agreements, each country has different laws, circumstances, and each agreement is different. And there are many clauses such as pricing, confidential, sensitive commercial information, competitive information. I mean, we're in a global market dynamic and a very competitive market dynamic as well. So any clauses that pertain to that is highly confidential and puts the business at risk. And if the business is at risk, it's the patient's benefit ultimately that will be impacted.
Thank you very much. Suivant, Madame Sinclair Desgagnés. Vous avez la parole pour...
Mrs. Sinclair Desgagnés. Thank you, Mr. Chair. I think that once again, those were very good questions from my colleague, Mr. Housefather, because there seems we're hearing messages, mixed messages, and I'm surprised because I thought I understood that you had practiced law. There's a confusion between industrial secret and commercial secret. Commercial competitiveness is never an exception to the Access to Information Act, and we're not even there. We are not making anything public. We are trying to do our work as parliamentarians and to keep this confidential among the members here. That's not even what we're trying to do. So first of all, confidentiality of the committee. Many of my colleagues spoke to this earlier. We see this on a regular basis. Parliament can require to see documents. We've done this recently for McKinsey, but we also did it in many other instances. My colleague asked the question, do you think that commercial contracts are more secret, should be more secret than defense secrets in Afghanistan? Well, at some point, no one is above the law. No one is above the Parliament of Canada. And at public accounts, we can require these types of documents. So here we are at public accounts. We're asking for the documents. If we go further and we speak about confidentiality and secrets, Mr. Tada, you described what's found in the contracts: price, quantity, localization, availability. None of those elements is linked to IP, and this is not an industrial secret either. Industrial secret, if I quote Judge Pellan in the AstraZeneca case, the type of information that is susceptible to be found in the category of industrial secret, the chemical composition of a product, and manufacturing procedures used. I'm also from the business world, and I've never seen a commercial contract that contained a chemical formula or manufacturing processes inside. There seems to be a misunderstanding here that needs to be clarified. I'd like for us to have the same definitions that are set out in the Act and have been for a long time. Thank you. Mrs. Desgagnés.
Desjardins, you have the floor for 2.5. Over to you.
Thank you very much, Mr. Chair. So I'm quite disturbed by the level of testimony provided to Canadians today and their representatives. We've asked simple questions about the paramountcy of Parliament and the direction of the Parliament Act, which is clear when you entered into the contracts with the government that the Parliament Act is supreme, and that you knew full well the risks by entering into a contract with any government, in particular democratic ones that have this potential of ensuring that we can, in fact, ensure that Canadians can shine the light on what's happening here. That's something that is going to happen across, not just here, but across the globe, I'd hope, in holding your corporations accountable. Absent of the scientific breakthrough, your corporate practices have been detrimental to the world. They've been hurtful in the ways that you've been unable to waive the TRIPS waiver, which has caused the potential thousands of deaths across the globe. It is important that Canadians understand that when dealing with the private companies, that this is the kind of hostage takeover situation governments end in, where they're sitting in front of us, accusing us of breaching our requirements to the public, and even going so far as to say that the government is in breach. And Mr. Housefather spoken eloquently to the fact of the risk that pertained to Canadians. I believe that risk is unfair. You have a conflict of interest. One, in your presentation today, you described how valuable it is to ensure that the lives of humans, in particular Canadians, are achieved. And then you've counterbalanced that by saying that your IP is so important that it's going to detrimentally impact your ability to negotiate elsewhere. Our perspective, my perspective, is the fact that across the globe, this disease is still occurring. It's hurting everyone across the globe, and you're trying to protect your IP in order to have better pricing for these companies. It's a kind of egregiousness that corporations, not just yours, are susceptible to because of the laws we make in our country. The government shares responsibility for the actions that you've taken here, which is why we need to have far stronger protections for Canadians in the pharmaceutical industry and tempering their appetite for Canadian profits, but also global profits at the risk of people's lives. Canada used to be a leader in this space. We used to have, as a matter of fact, in Winnipeg, the Winnipeg Labs, we had investments in these things. And we sold out Canadians to corporations that would otherwise hold us hostage now here today and threatening that they'd sue Canadians because of what is already agreeable to under the contract, which is the supremacy of Parliament, which is outlined clearly and identified by Mr. Housefather. I'm not happy with how this has gone, and I have no further questions. I hope you reflect on the importance of waiving the TRIPS waiver and save lives.
Thank you. I assume you mean you have no more questions for now. We'll come back to you.
I'll have another one.
Yes, I realize that. I'm just going to take a minute before I turn to Mr. McCauley. From my perspective, there's lots of great questions. The members' time is their member time. There are an awful lot of questions to the witnesses that deal with legal matters around Parliament. And they might be lawyers, but I just want to highlight that. We do have the legal clerk here. So if you do have questions, they can be directed to him as well. The witnesses here are here to speak about these contracts, their positions on them. I give members latitude, but I do want to say that sometimes I do sense some questions could be referred to the law clerk if you decide that's where you want to go. But again, it's your time, your decision. Mr. McCauley, you have the floor for 5 minutes.
Thanks, Chair. Witnesses, thanks very much. I just want to put a couple things to bed here. There is zero information on IP or anything in any of these contracts. Correct? So any talk about, well, it's IP that we're going to lose out, these are secrets, is misinformation. Lack of response I'll take is that I'm correct there. I want to go back to what I was discussing earlier. I want to look at just some of the comments from, I assume you're all paid members of the various chambers that wrote to us. You know, there's a comment here, 11 MPs in camera looking at these documents, you know, could hurt the business environment stability. Canada. Another one says it could wreck a reputation as a reliable partner in which to do business, worrisome precedent for someone wanting to invest in Canada. Such a decision could erode investor confidence and reputational consequences. So I want to get back to how many leaks have come from Canadian, Government of Canada procurement officials of your contracts? Let's just start with Pfizer and Moderna because those are big ones we're dealing with.
Thank you for the question. I am not aware of any leaks that have occurred
There have been
here in Canada.
Yeah, Ms. Coche?
Yeah, to my knowledge, I'm not aware of leaks in Canada.
Great, so there's been none from Canada. We've got leaks probably covering 90% of your vaccine business between the U.S., et cetera. These leaks, which some of them have leaked everything, other mostly, has this adversely affected Pfizer's investment in the U.S. or U.K., or Moderna's investment in the U.S. or U.K. or EU, or has negatively affected the business environment for dealing with them? Simple, quick yes or no, and I think the answer is no, but you can disagree if you wish.
So I'll start. I mean, I can't comment on the leaks that have happened in Europe. You know, we are...
But has Moderna said, well, geez, the EC, you leaked your entire thing. We're not investing in any EU countries anymore.
Yeah. What I can see is that Canada is getting the first mRNA manufacturing site from Moderna.
I'm not asking about Canada. Has
so
Moderna
I think it
pulled
speaks,
out investing or divested?
Yeah.
Or anything?
I can speak to what I know, which is that we are investing in Canada because of the very secure, stable, predictable environment that Canada has to offer, and we're not investing everywhere in Europe.
Does the EC not have a stable, secure environment?
We're investing in
Is
Canada
Moderna
given
pulling
the
out
environment
all of its
it offers.
investments out of the countries that leaked into Canada because MPs cannot see unredacted?
What I'm
and I
talking
think the
about
answer
is
is no. What I'm getting at is this whole argument about, oh, it's going to damage investment in Canada or Pfizer's not going to sell doses to us is a false narrative when probably 95% of your customers have leaked full contracts, but there's no negative or adverse effect on their investment. But this narrative that 11 MPs in a guarded room with no phones or copiers or any ability to copy anything is somehow a risk to Canadian investment from Moderna and Pfizer. So just putting that to bed. I'm curious, one of the contracts we saw from Brazil, and this is for Pfizer, stated Pfizer needed Pfizer's permission to donate any excess vaccines. Has Pfizer ever refused any country wishing to donate any vaccines purchased from Pfizer?
I can't speak on all of the contracts that Pfizer has signed around the world in donations. I can't speak about the process here in Canada.
I'm just asking, are you aware of any? Because the reason I ask, the government of Canada, we purchased a lot, but we've also had about $1 billion of vaccines stale date that we've had to discard.
30 seconds.
I am curious, Pfizer, again, the Brazil contract, one of the issues is, Brazil had to seek permission to donate to poorer countries or other countries. I'm curious, did Pfizer then perhaps refuse permission for Canada to donate excess vaccines to help out poorer countries abroad?
There is a process in place here in Canada, and it has been exercised for Canada to donate excess doses to other countries. In fact, it was made public that
Pfizer ever refused permission?
Mr. McCauley, I'm afraid
here in
that
Canada, we have not refused permission.
that is the time. Mr. Fragascatos, you have the floor for 5 minutes, please.
Thank you, Chair. I'm glad you pointed out the presence of our law clerk because I do want to start with a question there. Sir, is there anything that's been said with respect to the powers of parliamentarians to compel documents? A number of things have been said in that vein here today. Is anything that you've heard incorrect?
I heard references to the power to compel the productions of document and the committees, and this is a power that is delegated by the House of this power, and the committee has the right to compel the production of unredacted documents. Now, the committee can hear concerns and put in place safeguards or other measures with the view to protect confidentiality. And from the reading of the motion that the committee is debating, that is before the committee, measures with that purpose are proposed.
And this is a legal power. This isn't some kind of suggestion. This is something that carries the weight of law.
The power to send for records is part of the parliamentary privilege of the House of Commons. Privileges are written in the Constitution, so they're constitutional in nature. So they're legal and constitutional. They're also recognized by the Parliament of Canada Act, and per Section 5 of the Parliament of Canada Act, it is expressly stated that they're part of the law of the land of Canada.
Okay. I thought it was just important, colleagues, to make sure that we have the law clerk on record. If I could turn to the witnesses now, and I certainly want to ask you on the motion and what you're worried about with respect to the motion, but I also think about this from the perspective of our constituents, who ultimately we're representing. You've raised a number of concerns about the motion, but I wonder if you could explain those concerns in very basic terms, in terms of how, if this motion was to go ahead, how it would impact negatively the everyday person, economically, socially, and I'll give you a concrete example. In our health system, for example, would there be negative impacts for the overall well-being of Canadians in terms of the providing of necessary vaccines, or other impacts on jobs, for instance? I mean, if this motion was to go ahead, what would be the ultimate negative consequence for the everyday person that we represent in our constituencies? Because that's ultimately, I think, a key question that I think needs to be wrestled with as we debate and discuss the matter. So if we could start with Mr. Bellet and move to Ms. Sampson, Ms. Gauthier, and Mr. Tada.
Merci de votre question.
Thank you for your question. I cannot tell you today what would be the impact for your constituents. What concerns me is that information, such as the price, could be made available to my competitors, and this would be a problem for Sanofi. We operate not only in Canada, but in other countries as well. The price is one of the elements, but there are other elements in the contract that are important to protect, so that competition can be maintained in other countries as well as in Canada, according to international laws, and to not give a specific advantage to a competitor. This is my concern today as a representative for Sanofi.
Would be to the everyday person, to the nurse, to the teacher, to the firefighter, and so on and so forth. Something like this goes through. How does it make their life? How does it jeopardize anything in their lives? Potentially.
I appreciate the question. Thank you. I think what I would say, and I live here in Canada, and I have close to 1,000 colleagues and employees here in the country. Just to go back, I think that Canadians recognized how swiftly the government and vaccine manufacturers moved in the wake of the pandemic to ensure that these vaccines were made available as fast as possible. There is an unprecedented level of cooperation up to this point, and I think that resulted in the protection and saving of lives in Canada across the board. And hopefully everybody understands that.
There's limited
and is aware
time.
of that.
With great respect, I'm sorry, Ms. Gauthier, if you could.
I mean, this is a hypothetical question, so it's quite hard to answer. What I can say is the safeguards that we have in the agreement have allowed us to focus on bringing doses of vaccines for Canadians. December 24, 2020, we had 168,000 doses that were landing at Pearson just on time for Christmas, before what we were planning for. We turned every stones to bring doses of vaccines for Canadians, and that's because we knew that we had safeguards of confidentiality in the agreement, so we could focus on what mattered for Canadians. So that's what we did. So I think hypothetically, we can think about if the environment changes, what would happen. I can leave it to...
And your work is very much appreciated, to be sure.
Witnesses, the clerk just remind me, and I'm sorry this is coming so late. We're going to keep you here beyond 6 because we started late, so I appreciate your patience with us. There'll be another series of questions. I should have mentioned that off the top. Often this is standard that when the House holds up votes, committees start late. So if you'll please indulge us. I will endeavor to move things along quickly. Mr. Cram, you have the floor for 5 minutes.
Okay, thank you, Mr. Chair. I would just like to circle back to the Auditor General's having access to the unredacted documents. We heard from Pfizer already, so I wonder if we could just quickly hear from the other 4 companies. Were all of you opposed to the Auditor General having access to unredacted copies of the contracts?
Merci de votre question.
Thank you for your question. I confirm that Sanofi did oppose the distribution of an unredacted copy of the document to the AG.
Beaucoup de votre question, et je dois avouer.
Thank you. I must say that the past 2 years are a blur. I was alone in managing a company and trying to provide millions of doses of vaccine in Canada. I don't even remember how it happened at the time. I'm not actually able to answer your question factually.
And Mr. Tata, we haven't heard from you in a while. If you could answer as well, I'd appreciate it.
Yeah, I can't comment on the general audit, but now, given the situation we face now, we are not opposing to the full disclosure of the unredacted copy of the contract to the committee, as long as confidentiality is kept. Thank you.
Okay, thank you. And so to Mr. Baylett and Ms. Sampson, so did you communicate your concerns to members of the government before they provided unredacted documents to the Auditor General?
Je vous confirme. Merci de votre question.
Thank you. I confirm that Sanofi communicated in writing its concern in the sharing of the document, sharing of the unredacted document.
Thank you for the opportunity to clarify. Pfizer was not a part of the process. So I think that, again, we would have expressed our concerns if we knew that the unredacted contract would have been provided to the AG.
Okay. So the government just provided the unredacted documents to the Auditor General without your knowledge, and after you found out that had happened, then you voiced your concerns. Am I understanding you correctly then?
We would have voiced our concerns at that time.
Okay, but you haven't voiced the concerns about the documents being given to the Auditor General because what's passed is passed and it's water under the bridge. Is that correct? Okay. Did you communicate your concerns to the government about providing the unredacted documents to this committee? To both of you.
Yes. We have discussed this in the past. I think both sides have agreed that the confidentiality clauses should be upheld in the contracts. I know the government isn't here, today to share their opinion, but it is worthwhile to understand their perspective.
And Mr. Bélat?
Je vous confirme en effet que
I confirm that we asked that the unredacted version not be distributed to the committee.
And who in particular did you talk with? Was it politicians? Was it civil servants? If you could elaborate, please.
I don't have those names, but I can come back to the committee with those names.
je n'ai pas le nom des personnels.
I don't have the name of the government staff, but it was a procurement team.
Was staff and not elected officials. Is that accurate?
C'est correct.
Yes, that's correct.
Okay. Let's see, what else do I have? Let's shift gears a bit to Bill C-290. This is a bill that is before Parliament to, it's called the Public Sector Integrity Act. It's about strengthening whistleblower legislation. Do any of the witnesses have any position on this particular bill?
I just heard of the bill today. I have not had time to read it, but what I can say is that, in terms of governance, whistleblower, protecting people raising issues, this is very much aligned to the values of Moderna. So I look forward to reading the bill and having further conversations.
And that is the time, Mr. Cram. I'll now turn to Mr. Housefather for 5. You have the floor.
Thank you, Mr. Chair. I want to come back to where we were. So to start with it, I think it's really important to have all of you here to convey what your position is and to get clarity on what that position is, because we're talking in vague generalities of we want to protect this, we want to protect that. And I think it's important to get to very specifically what you want to protect and why. And the fear that you have is clearly somehow that this committee will leak the document, because you would have suffered no damages in the event that the committee didn't breach confidentiality and it was only the members of the committee that had it. So I struggle a little bit to understand why you would trust the public servants more than the members of the committee, particularly when they would be in a room with the law clerk and wouldn't have access to any phone or any device to actually see, like to take a picture of the agreement or anything like that. It would be only their unaided memory that they could leave the room with, and then they would be in breach of the rules of Parliament if they actually divulged. So I want to come back then to cut to the chase. The agreement.
Mr. Housefather, just a small point of clarification. I stopped the clock. The law clerk's not part of the motion, just so you know.
I thought it was in his office.
Clerk's office, I believe.
Clerk's office. Oh,
yes.
excuse me.
Yeah.
Clerk, law clerk.
Yes,
Got it.
exactly. Yes. Starting again.
Sorry,
time
thank
is
you,
yours.
Mr. Chair.
Yeah.
So can I come back again? I want to, because I really do want to understand, because I think it is important where you have the concern. So the concern is obviously only if somebody breaches. Price, I understand. Price is a question, a competitive issue. You don't want other countries to know what price you give Canada. Some of my colleagues have talked about intellectual property. I, again, have very rarely, although on occasion, I think in the European Union leaked document, there actually was some trade secret information that related to a process to manufacture the vaccine. But I would assume that it wouldn't likely be in this contract, but if it were, I could understand again that if you had trade secret information related to the composition of the vaccine, how you process the manufacture of the vaccine, although again, I don't know why the government would need to know that, that would be information that would be very important not to have disclosed to competitors unless it was patented, in which case it would be public. So other than that, other than price and trade secret information, what other clauses, Pfizer, please, what other clauses would be confidential?
Well, and thank you for the question. I think we're talking about protecting the entire agreement and the confidentiality of the entire
I'm sorry. The terms under which you deliver, if you deliver FOB origin or FOB destination, that is not in any way information that could harm you if that was disclosed publicly. The terms of the confidentiality clause of the agreement, what terms you used, that's not something that would harm your business if it was disclosed publicly. Whether or not it was subject to the law of Quebec or the law of Ontario wouldn't harm your business if it was disclosed publicly. If there was an arbitration clause, that wouldn't harm your business if it was disclosed publicly. I want now specifics. What are the specific clauses in the agreement? And you're going to have to explain to me exactly why they would harm your business. Please give me the exact clauses of the agreement that you feel are confidential, that couldn't be disclosed, and that you would have actual business risk in the event they were disclosed vis-a-vis your competitors or your international market.
Well, to be as specific as I can, I think that there are parts of the contract that deal with supply and supply schedules.
Okay.
We have actually more than one vaccine, so information as it relates to our different vaccines and the differences between them, a lot of those are proprietary. It's proprietary information, but it's also very commercially sensitive. And when we talk about Canada and the contract that we have in Canada, it actually does impact, it could be seen as something that is of interest in other countries, because we also have these confidential contracts in other countries. So I think, again, we're talking about the contracts holistically, but there are definitely components that are commercially sensitive for us from a competitive perspective, proprietary for us, but then also could impact or prejudice some of the discussions that we're having right now as we speak with other countries around the world.
So again, I understand. Like, again, I come from this background. I was the general counsel. I understand there are certain parts of a contract that if they become publicly disclosed, again, that would presume the committee would publicly disclose them somehow, they could harm your ability. For example, if you priced one country different than another, if you had a supply schedule that said that we were favoring shipments to one country over another, and this would become public, that could harm your business relationship with other countries. I fully understand that. But there are many, many, many clauses of the agreement that would not, right?
That is correct.
Right. So I'm asking in terms of redactions. You want to redact, you're proposing to redact trade secret information. Trade secret information would be how you make the vaccine and how you manufacture it. I don't think many people would have a problem with not seeing that. I personally don't think. Then you're proposing pricing. I'm not sure if that would or would not be a problem, but that pricing. You're also talking about now the schedule of deliveries, which, given the fact that these schedules really were during the pandemic several years ago, and I know that there's still ongoing vaccine deliveries under new amendments to the agreement, but that's
Father, I'm going to have to stop you there, but I think your time is up. We will come back to you as well. So,
yes, thank you.
Yes, and you'll be able to press that point one last time. Madame Saint-Claude-Desgagnés, vous avez la parole pour 2 minutes 30 secondes, s'il vous plaît.
Thank you, Mr. Chair. I have a simple question. It's a yes or no question. When you set up the contracts with the Government of Canada for vaccines, did you know that there was a parliamentary process for access to information? No? Did you know that there was a disposition of Parliament for access to information when you signed these contracts? Testing 1, 2, 3. Test 1, 2, 3. Testing 1, 2, 3. English translation 1, 2, 3. Test 1, 2, 3. Testing 1, 2, 3.
Why don't I talk?
I'm going to speak French for a few minutes and see if. Okay.
And not count against your time.
Can I have my time?
It does your stop. You're good.
I have to repeat the question twice.
Well, I'm going to repeat it right now. Were you aware of the parliamentary oversight that is part of our system, that there was a possibility that parliamentarians could review these contracts? Close enough? Oui? Okay.
I was not aware that we could review the unredacted contracts here.
Merci. Madame Gauthier? Je faisais pas partie.
I wasn't part of the first team that negotiated the first contract that was at the basis of the other ones, so I can't tell you what they knew. I was only involved in the contracts that amended and added to. In the amended, were you aware of parliamentary oversight? Honestly, this wasn't the focus of my negotiation, even of my thinking, and I'm saying that quite honestly. There were so many things happening at that time that it wasn't top of mind. Would you have liked to know that? Would it have changed your advice? with regards to signing contracts with Canada, or would you have provided vaccines to Canada anyways, knowing that there was this parliamentary oversight? It's important for us to know what these dispositions are and what can be the impact on us. Would it have changed our negotiation? Probably not, because we have within the contract a rule of confidentiality, and it applies to Sanofi as well as the government.
I can't say whether it would have changed what we did during that time. Again, I think our focus at that time was ensuring that we got as much vaccine out to Canadians as quickly as possible and with the highest level of quality.
OK, parfait. J'ai combien de temps, Monsieur le Président?
How much time do I have left? 30 seconds? Perhaps during the next round I'll have more time to raise an important element that you spoke about, the motivations behind a refusal. And I understand a business wants to be able to charge the price that they want as anti-competition practices. But there are institutions that exist in developed countries and also in third world countries to fight against anti-competitive practices. And it's up to the government to be on the side of consumers and citizens. Thank you.
2.5 minutes.
Thank you very much, Mr. Chair. I do want to now turn to an important piece of work that we do here, which is ensuring that we have regulations for the protection of Canadians in relation to preferred contracts, but also how people like the representatives of your company come into these contracts with Canadians. It's an important piece to understanding how it works here. Part of that is the lobbyist registry. It's very clear that your companies, through various ways, have been able to have access to the government to ensure that your perspectives were heard very quickly. I understand that not all of the companies, including Moderna, aren't part of this, my following statement. But in relation to Innovative Medicines Canada lobby, it's a large lobby group here on the Hill. Many of us are aware of their work. Many of us have had to meet with them many times as your advocates for oftentimes commercial interests. And so it's obvious that each of you work together, and you work closely together, probably far closer than you are with Parliament at this time. And it's oftentimes these requests are to increase your profit margins rather than the public needs of Canada's people and industry organized by Innovative Medicines Canada. So my question is in relation to how many times did Innovative Medicines Canada lobby the federal government during the pandemic? Are any of you aware of how many times that is?
Sorry, I'm not aware.
No. How many times did I looked there, and you've met with dozens of the public office holders ranging from MPs to deputy ministers and senior staff in ministers' offices in just the last year. Why do private companies lobby the federal government is a big question that I have. And so why do you lobby the government? What's your interest? Jean?
Alors, merci de votre...
Thank you for your question. Unless I'm mistaken, in order to meet with members of the government, you have to be on a list, on a list of lobbyists. You have to register. And we have to register who we're meeting with. This is a legal obligation, and Sanofi.
Je crois que j'ai répondu à votre...
I think I answered. I'm part of the list. I meet with...
Why does Moderna lobby? Sorry, monsieur.
C'est une très bonne question.
That's a good question, and I'll tell you. Someone mentioned that there was a lot of learning. I think it was you, Mrs. Sinclair de Gagné. There was a lot of learning during the pandemic. I can tell you that I spoke with elected members in order to crystallize what we've learned following the pandemic. We all suffered in Canada, and you represent your constituents. And
Canada, we absolutely must continue crystallizing the learnings from the pandemic. So I have been having discussions with them to make sure that as we move forward, the amazing work that was done by many Canadians, by many government officials and public servants serve as a new way of working into the future.
And
so I've been having discussions with them
very
about
much.
that.
Mr. Desjardins, you have one more round. Turning now to Mr. Genuis, you have the floor for 5 minutes.
Ms. Sampson from Pfizer specifically, can you confirm that your company retained McKinsey for what period, and is your relationship with McKinsey ongoing?
I'm sorry, could you be a little more specific?
McKinsey and Company?
Pfizer Canada?
Pfizer Canada first, and then Pfizer globally. Yeah.
I will get back to you. Unfortunately, I don't have that information with me right now, but I can submit that to the clerk.
Okay, you're the president of Pfizer Canada. You don't know if you've ever retained McKinsey, either way.
We have.
If I may, on this one, I could clearly say that we never worked with McKinsey related to any contracts for vaccines or any other contracts in Canada.
Has Pfizer Canada retained McKinsey in recent years? Mr. Paquette?
I'm not aware of any contract that we have with McKinsey outside of what we can do in my area, which is for vaccines.
You're not aware of anything outside of that area, or you're not aware of anything in that area?
I'm not aware if we've worked or not with McKinsey. I know that in vaccines, we haven't for the contracts, that's for sure.
Okay. It has been reported in the media that McKinsey has done work for Pfizer. It's been reported that they were simultaneously advising governments on their COVID response. And it's also been reported that McKinsey was advising a provincial government specifically on negotiation of agreements. So I would appreciate a follow-up in writing to the committee. Now, in also staying with Pfizer representatives, in 2009, Pfizer and one of its subsidiaries paid over $2 billion in the United States in a healthcare fraud settlement, resolving civil and criminal liability related to Bextra. And I think instances like this underline for me the importance of accountability and oversight and not taking a just trust us approach when it comes to companies like yours. How much has Pfizer paid in Canada in the last 20 years in settlements related to false claims or faulty products?
I am not aware of any settlements that we've paid in Canada. I can bring that back to the court if there are some, to the clerk if there are some, but none that I'm aware of. But I am glad that you raised that, because that is, it's a matter of trust, right?
Yeah,
and
it is a matter of trust. And so I'm just trying to understand, you said that you're not aware of any settlements paid in Canada. There have been multiple, billion-dollar-plus settlements related to Pfizer's products in the United States. Is the reason that settlements haven't been paid in Canada because legal action hasn't been taken, or because our laws are different, or because those drugs weren't marketed here? What's happening with Pfizer Canada that's different?
I don't have the answer to that question, but I can follow up with that.
Okay. So you're not aware of what Pfizer may have done in terms of work with McKinsey. You're not aware of settlements in relation to faulty products or false claims made in Canada in the last 20 years, and you have worked for Pfizer for decades, if I understand right, Ms. Sampson. You're not.
That's correct.
Okay, thank you. Are there indemnification clauses in these contracts related to COVID-19 vaccines? And could you share a bit with us about the indemnification clauses?
Sure. I am not at liberty to speak about the clauses specifically in the campaign in the contract that have not been publicly communicated. But what I can say is that the purpose of indemnity clauses overall is to ensure that patients and consumers have a pathway to...
To be fair, the purpose of indemnification clauses is so you don't get sued if there's a problem. That's what indemnification means. Can you just confirm that there are indemnification clauses in these agreements? Sounds like you won't tell us about them.
Indemnification is standard. So I will say that.
They are in these agreements then?
They are standard across the board.
So they are they in these agreements?
I can't comment on any clause in our contract.
Can you just tell us if there are indemnification clauses in these contracts that you sign with the government related to COVID-19 vaccines?
I cannot comment on anything in the confidential contracts, but I can say that there are pathways.
You can't even
that are
tell us if
available.
there are indemnification clauses.
And thank you
Unbelievable.
very much. That is the time. Miss Shanahan.
I'm actually going to take that time.
Okay.
Thank
That is
you.
good, because I was worried there for Ms.
Yeah, you wouldn't
Shanahan.
want her to have to.
Mr. Housefather, you have the floor for
Thank
5.
you. I think in response to Mr. Genes's question, indemnification clauses exist in all agreements. They're a standard thing. But I would think that based on what I've seen from the leaked documents, the indemnification clauses in COVID-19 agreements were vastly different than the indemnification clauses in normal pharmaceutical contracts, given the development of the product, and governments took greater responsibility in all of the documents that I've seen. So let me come back again, because I really want to. This committee, as you all understand now, because maybe it wasn't so clear before, has the power to compel the government to deliver unredacted versions of the contract. They have that power. This committee has that power. So in order for the committee to not exercise that power, you need to be able to convince the committee that there are actual harms that would be suffered by the people of Canada, by the government, by you, by somebody, if redacted versions were, if it was unredacted versions were delivered. I again come back to the question of, as I would read a normal confidentiality clause, the fact that the law of Canada, the Parliament of Canada Act, obliges the government to deliver that would mean they were likely not in breach of the agreement, provided they followed the other stuff in terms of giving you the right to seek protective orders, etc. So I want you to have that opportunity now, again, clearly to convince the committee why the committee should say, even though we're entitled to unredacted, this should be redacted. So I understand it for trade secrets. Again, I understand it for trade secret information. I may understand it for pricing and delivery schedule. I mean, I'm less hesitant on delivery schedule, but pricing, I understand. What other clauses in the agreement specifically could potentially harm you in terms of having a stable relationship with Canada? Because you have a right to work in a stable environment. I agree with that too. You invest in a country because you believe in stable relationships, even though there's a parliamentary committee that was not likely to divulge what they see. Can you maybe, again, I'll try Madame Gauthier this time, because I asked Ms. Sampson the last time. Could you give me specific clauses that Moderna would say, wow, these are really sensitive, we would need to have this redacted before it goes to the committee?
So these agreements are very long and complex and have been amended a few times because situations have evolved and we've had to adjust to the situations. So, and I have not, full disclosure, reviewed the agreements before coming here in details. So again, you talked about indemnity, you talked about pricing, you talked about trade secrets. There could be some IP. IP is not just a full-on like 5-pager of like a recipe for a vaccine. IP can be weaved into some areas, so there could be some IP in the agreement in areas. I mean, anything that has to do with supply chain is really sensitive and confidential.
If you've disclosed,
as well.
again, if you've disclosed who your suppliers are and how, and the terms you have with your suppliers and their third-party information in there, I get that. I don't see that in many contracts, but I would get that. I don't know where IP is normally weaved into a contract. Again, I've worked in IP and technology my whole life, and it's very rare that you would be mentioning IP, but again, an indemnity clause, I don't know why the indemnity clause in particular would be harmful to you guys, particularly in this context, given what I would imagine is in that indemnity clause. So I appreciate it, but I mean, you have to understand again the situation here, right? You clearly have a majority on this committee that would believe that they want unredacted documents to be delivered, and unless you can make specific compelling arguments, it's likely that the committee will adopt that kind of a motion. So again, I want to give you that chance to offer me those compelling arguments as to what will happen that you believe will happen. And again, I get trade secret, I get price. Other areas that you need, and what would happen if they just went to the committee and was never disclosed to anybody else?
We entered into these agreements within rules of engagements. And I don't think these conversations that we're having right now were part of the considerations of these rules of engagements at the time. So The context in which these agreements were entered into is very specific. The context in which these contracts were entered into in other countries, in the European Commissions, in the US, where there was BARDA support in Moderna's case, are very, very different.
So let me ask a question. Would you then have this problem if it was a contract, a different type of contract, not a vaccine contract under COVID-19, but a standard contract you entered into to sell a different drug? Would you have the same problem, or is this very specific to this unique set of circumstances in this unique contract?
Mr. Housefather, you're going to hold that question. You will have one last round. Pardon? Pardon?
On peut entendre la réponse.
De tous les trois?
We'd like to hear the answer. Or at least one.
Si c'est une oui ou non, mais brièvement. Do you want...
Yes or no?
It'll be a short answer.
Okay. Thank you for your honesty.
Sorry.
Okay. Look, I'm going to do one more round. I'm going to give the witnesses the option. Would you like a 5-minute break? Would that be, we can either get it done off like quick like a Band-Aid, or I'm happy to suspend for 5 minutes if you'd like. Okay. I was just checking. So, all right. Mr. Macaulay, you have the floor for 5 minutes. This will take less than 30 minutes in total, just so you know that. Mr. Macaulay, over to you.
Thanks, witnesses. And first of all, I want to say, I have a great appreciation of Big Pharma. There's one of the large ones, not represented here today, that has donated an amazing amount of life-saving drugs to children in Edmonton who are suffering from SMA. So this is not described like a hostile event. We are just trying to understand why we have contracts that have been leaked around the world. We've got all the details. I'm looking at a website, investors.com, where president of Moderna is quoting what the new price they're trying to get out of the U.S. So I'm trying to struggle how we're arguing about hidden price when it's public, because he's going to war with Bernie Sanders tomorrow, with the current price and the future price public, and how this is going to hurt commercial or affect commercial sensitivities. I'm looking at the Pfizer contract leak from the U.S., and it actually states 1193 that the receiving party, the government, can release confidential information if required under legal or administrative proceedings. So we already know Pfizer has already agreed in the U.S. it will release it if required, as Mr. Bernard says. Like, none of this is up for argument. You were invited here to explain what Mr. Housefather's much, much better explained or asked. Like, why are you opposed to us seeing some of these things? And I'll admit great frustration that we keep asking simple questions, especially around these implied threats to Canada. Ms. Gauthier, you mentioned, we were able to deliver by Christmas Eve, for great profit. We're able to deliver by Christmas Eve because we knew, these were being confidential. As if it was implied that if it wasn't confidential, that they would have withheld these vaccines from Canada. And it's almost partial when you consider, again, probably 95% of your combined business is in contracts leaked that I have copies of, that you've stated you clearly have not divested from these countries, you've clearly not withdrawn any access to vaccines. So it's almost like you're continuing this charade of the only reason we're doing this out of the goodness of your hearts is because these things are confidential. So I wanted to address that. But also, again, Pfizer's clearly already stated in their contract that got leaked, but not from Canada, that they could hand it over. But again, it's like we are going to sit under guard of our very able clerk without any phones, without any cameras, without any copiers, without any, I'm sure, pens and papers to copy anything. Like, what is, honestly, the great concern that 11 of us with zero ability, unless Mr. Housefather will give him points, has a much better memory than a lot of us. He might be able to memorize a couple of these words, but what is, again, the great concern of blocking 11 MPs from seeing this with the great oversight provided in the motion by my colleague from the Bloc? When everything's already been leaked, government of Canada hasn't leaked anything, even though there's 100, 200 public servants have full access to this, whether it's procurement or on the legal side. What is this great pushback that you're you're spinning, your allies, your paid allies are spinning this great narrative that it's going to be a great disservice to Canada, costing jobs and lives, if 11 MPs sit in a guarded room for a day with zero ability to copy anything. Like, why, again, this pushback and spinning this Hollywood-style narrative, I would say, about the dangers
1 minute, Mr.
of Parliament looking at it. Ms. Sampson, I'll start with you.
You know, respectfully, I don't think that any of us, especially me, I'll speak on behalf of Pfizer, is trying to downplay the great responsibility that this committee has. So I just want to be very clear about that. I think in this particular case, it is the confidentiality that we expect from all of the contracts that we enter into.
Okay. But your confidentiality has been blown by other countries. And your own contract in the States, quote 1193 states, you're happy to provide the information if it's required by law. And it would be required by law. Canada hasn't leaked anything. We would have zero ability to leak anything. And yet, you're spinning this narrative, oh, well, it's a business thing, you'll lose lives, you'll lose jobs to Canada, you'll lose investment. But that doesn't reflect the facts around the world. So what is, again, the pushback?
Thank you very much. That is the time, Mr. McCauley. I am going to kind of watch the clock closely now. Mr. Housefather, you have the floor for 5 minutes.
Thank you very much. So I'm coming back again. The concerns you're expressing, again, I guess I want you to try to think, I'm trying, and I have tried to put myself into the context of what I would feel if I were the general counsel at one of these companies. And I'd like you to sort of put yourself in the context of what you would think if you were a member of the committee, right? There seems to be, I guess from the position you're taking, a feeling here at least, that there's a distrust of the members of the committee in a way that you didn't just trust the public servants. As Mr. McCauley said, there's many public servants that have access to this contract, whether in the legal department or the procurement department, et cetera. And this would be a motion where a limited number of parliamentarians would view this document in a room without the aid of any equipment to take pictures of it or to copy it, which the civil servants actually would have the contract, and who knows, right? So I think I guess I'm pleading with you to sort of reconsider, let me ask you first a question. Is the concern you have that if you allow, or you say you would allow, parliamentarians in one country to see the document, you would be concerned then that parliamentarians in other countries would mimic this exercise and would somehow see the documents in different ways that wouldn't be equally protected as they are in Canada? Because that might be a good reason. Can you let me understand? Is that one of the issues? Any of you?
I think it's a very, very good point, and it's the reason why Pfizer has just a policy in general about these contracts. We do everything possible to uphold the confidentiality in them, and that includes not providing them unredacted.
No, but I understand, but we're the government of Canada, we're your client, right? The Parliament of Canada is an organ that ties to the government of Canada. The Parliament of Canada Act says that parliamentary committees can require documents. So when you signed the contract, whether or not you had knowledge of that, if it says in the confidentiality clause, which again I have not read because I haven't seen the agreement, but it would seem to me, because every clause I've ever drafted in my life on confidentiality would make an exception when the law required one of the two parties to divulge the contract, and then would give remedial measures to the other party to seek protective orders or whatever. You're putting, I think here, the government into a difficult position where you're insisting that somehow a breach would occur. I don't necessarily think a breach would occur, but you're also not explaining well why this committee, in the method described, would be likely to breach. So can you perhaps then, let's go in a different direction. Look at Mrs. St. Clair de Gagnier's motion and tell us what changes would you like to that motion to make you feel more protected if the committee passes the document? For example, would you like to be in the room when they look at your contract? Would you like to have representatives there to watch the process? What could you suggest concretely that would be a change to the motion that the committee should consider? Any of you? Madame Gauthier?
So I'll start. I think your question around the precedent is a really good one, and I think one not to take lightly, because there is Canada and there's many other countries in the world, and leaks have happened. So again, like the precedent you just raised, I think is a very valid concern globally. So I think that's one piece.
But concretely, if you assume the committee will vote yes, what changes would you like to see to this motion to make you feel more secure? I know you've come here hamstrung by positions that you can't change necessarily at the table, but this is not one of those questions. This is a question of, if the committee goes ahead, what in there is making you feel insecure that you would like changed?
So again, not to negotiate here, I think we have more capable teams of doing that than us here tonight. But considering terms and conditions to uphold, the safeguards around confidentiality would be really important, such as non-disclosure commitments, as an example, like non-disclosure agreements, things like that could potentially, again, here I'm talking very hypothetical, not making any commitments, but I think we need to uphold the confidentiality of these agreements, and they cannot, we need to respect the terms and conditions without breaching them. So I think thinking about another legal mechanism that allows us to do that, such as non-disclosure agreement, could potentially, hypothetically, be something that is discussed between our teams if that was something. Again, very hypothetical, but just trying to be solution-oriented.
Thank you, Mr. Housefather. That is your time. Madame Secrétaire Desgagnés, vous avez la parole pour 2 minutes 30 secondes.
2.5 minutes. Thank you. I'd like to ask Mr. Beda, I don't have a lot of time. Could you remind us the conditions of confidentiality that are indicated in the motion and to what extent they are robust? Is that the documents would be provided to the clerk of the committee? Members of the committee would be able to consult the documents under the supervision of the clerk without having any electronic devices. Could you speak to the robustness of this with regards to confidentiality? If there was follow-up with the motion, because it would be considered in camera, there would be a sanction if someone would disclose. So robust sanctions would be in place. We have confidentiality measures that should normally suffice. I'd like to perhaps ask another question, a direct question, a yes or no answer would be appreciated. Mr. Bedard, on the basis of the arguments heard here, especially they were on a commercial nature or a competitive nature, could you tell us if there were reasons for which the House could decide that no, parliamentarians of the committee have no right to see the unredacted documents? Do you think that there is sufficient evidence on what you've heard today to say that we at the committee have no right to see these documents? It's up to the committee and the House. Yes, but on a legal basis, on a legal basis, this is a power that can be exercised by the House, the power to see. So the simple answer is no. Great, thanks. 40 seconds? Great. So the ultimate argument, you've heard it on legal arguments and precedent, also these, and given the sensitive nature found in the contracts, we have acted in good faith, and I would like for you to reconsider the approach, and I know that there are some reasons why you don't want to, but either it will be done in camera by this committee in a confidential and safe way, or it will be through the Access to Information Act and then perhaps made public. Thank you.
Have your final 2.5 minutes, please.
Thank you, Mr. Chair. I do want to thank Mr. Housefather for his attempts to ensure that these corporations had an opportunity to demonstrate to Canadians why it's so important that these aspects of confidentiality are met. Of course, you can tell I'm not satisfied, nor are the members satisfied, I'm certain you're going to have to now deal with an unfortunate circumstance, which is an unwilling partner to ensure that the government is actually protected. And so I sympathize in many ways with my Liberal colleagues, and it's more disappointing to know that we've entered into contracts with such companies who would not, one, understand the supremacy of Parliament, two, understand that any contracts that you in the dealings of a country like Canada would be subject to the Parliament of Canada Act, which is an important lesson I hope you learned here today, and something that is incredibly important for corporations working in any setting to actually understand. You do not have the right to circumnavigate democratic institutions, nor do you have the right to treat members of Canadians' representatives the way that we have today, with what I believe is obfuscation of the truth in many aspects. And we're left with, I think, the same amount of information we began. We have no more information than we began this meeting with. And so it's almost now incumbent upon this committee to ensure that this motion is adopted. And I'd question why the government would vote against it, considering the facts you've heard today. You've learned nothing more than we have. And you should also be concerned with the fact that these corporations have the opinion that they can do what they're doing, in fact, try to conceal documents from Parliament, knowing that the law clerk has given clear statement as to the realities present to these corporations and their liabilities to Canadians and the ability of of our Parliament to second these documents, even without the protections that we've spoken about. And so I hope you can see that it's a generous offer by Madame Sinclair-Dagané to actually ensure that your contracts were protected. And it seems to have not been seen like that. And it's a great offering to your corporations to protect the things you're talking about, or lack thereof talking about. And so I'm going to be very interested in entering the debate on this motion. We have no further information. I'll give 10 seconds each to see if whether or not there's any more information as to what is so confidential about these documents that you don't want us to see, in the vein of Mr. Housefather one last time. I'll start with Ms. Gaucher.
I'm afraid you are out of time, Mr. Desjardins, but I'm sure that Mr. Housefather is going to pick up on this in his final round. But before that, we're going to hear from Mr. Genuis for 5 minutes, who you'll be splitting your time, I understand, and I'm going to let you do that. So, okay, go ahead.
So, Chair, we have a motion before this committee that involves 11 members of Parliament on one of the most important accountability committees being able to look in private at vaccine contracts between the government and big pharmaceutical companies that produce COVID-19 vaccines. And companies are so desperate to hide this information, and they can't tell us why, they can't tell us what they need to hide. And I have to say, after today's hearing, I am more convinced than ever that it is critical for us to access these unredacted documents. If there is such a desperation to prevent 11 members of Parliament from looking at these documents in private with no intention or capacity to leak, and in any event sanctions if they were to, it underlines, I think, a question top of my mind, which is what is in these contracts that you are so desperate to hide from 11 members of Parliament. So I hope this motion passes quickly in light of your testimony today, and I hope we'll have the support of all members of the committee. There's been some discussion about precedent. Allowing you to hide this information would set a very bad precedent. Denying the supremacy of Canada's Parliament would set a very bad precedent. And anyone doing business in Canada can know and frankly be protected by knowing that Canada is a country where Parliament, not the executive, is supreme. And finally, I want to confirm that representatives from Pfizer agreed to provide follow-up information regarding the amount of settlements in the last 20 years in Canada regarding false claims or faulty products, as well as details about whether Pfizer Canada or Pfizer globally retained McKinsey in the last 5 years, for what, and in particular, whether or not for anything related to COVID-19. Ms. Sampson, can you just confirm quickly that you'll be able to provide that information in writing?
Well, thank you.
Thank you, and I'll turn it over to Mr. Cram now.
Mr. Cram, you have 3 minutes.
Okay, thank you, Mr. Genis, Mr. Chair, and to all the witnesses. I guess I'll just tie up a few loose ends here. We already heard from Ms. Gauthier about Bill C-290, the Public Sector Integrity Act. Do the other three companies have a position on this bill?
I have not had an opportunity to read the bill.
Okay.
Non plus l'occasion de lire
I have not had the opportunity to read it.
Okay, and
I haven't yet either.
okay, I'd like to shift gears then, and I'd like to come back to Ms. Sampson, since I believe about 2/3 of the vaccines administered in Canada were from Pfizer. I was wondering if you could give us some insight as to the timeline about the signing of these contracts. It was reported in the media that Pfizer signed its advanced purchase agreement with the Government of Canada on October 26th, 2020. But the contract with the United States was signed about 3 months earlier on July 22nd, 2020. Can you explain how it came about that the contract with the United States was signed 3 months before the contract with Canada?
Knowledge of the details and when and why the contract was signed early in the U.S., but I would like to ask my colleague, Mr. Paquette, to talk a little bit about the timeline for the vaccine negotiations here in Canada.
Thank you, Nadja, and thank you for the question. The actual first agreement that was signed and communicated was in August of 2020. So that was the first agreement that Pfizer signed. At the moment, that was an early agreement to actually establish the basis for a more detailed agreement later on. So that was basically a couple of weeks after the US, and amongst the first in the world after the US.
Okay, and finally, as anyone who remembers the 2021 Stanley Cup playoffs can tell you, in the spring of 2021, all of the arenas in the United States were full, and all the arenas in Canada were empty. Can anyone provide any insight as to why Canada's vaccine rollout seemed to be a few months behind the rollout in the United States?
I could actually provide further guidance on this and mention the fact that in 2021, in Canada, Pfizer alone delivered over 55 million doses, which is way above what was initially in the contract. So, in other words, Pfizer has been able to deliver more vaccines faster in Canada than what was initially planned in the contracts.
That's really your time, Mr. Cram. Yeah, so, and Mr. Housefather, you have the last 5 minutes. Over to you.
Merci, Monsieur le Président, et je remercie encore.
Thank you, and I'd like to thank the witnesses. I understand that it's not easy to testify before a parliamentary committee, and it's not necessarily a fun exercise, and I really appreciate the work that you've all done. Now, we are here in this situation where the committee has the right to ask for certain documents, and in fact, I'm going to give you a chance once again to tell us, if we take Mrs. Sinclair de Gagné's motion, how can we perhaps amend the motion so that you will be more comfortable? Would you like to have a representative of your company in the room when the MPs will look at the documents? Would that be helpful?
Anyone? Oui, no?
Yes, no?
Je vous propose de...
I would ask you to review the conditions for access to documents with our legal teams, and I will look over this with my legal team and come back to you.
I think that ensuring that our legal teams are involved is important. Ensuring that there is their confidentiality protections would be important. But I also think it would be good just to understand if there are any specific concerns that the committee has, and maybe there are things that we could address proactively with that.
Madame Gauthier?
Je pense que je me suis déjà...
I've already spoken to this. We're not going to solve this this evening. We could discuss with our internal teams. If there are specific questions that we can help you to understand. Honestly, I don't think the committee... I mean, you're here and you see the questions that are being asked. I don't think that a majority of the committee would be satisfied with that. So certainly there will be a request to disclose the documents that will be sent to the government. And I think also that there might be a vote today on this. If the motion was amended, to say, for example, that before the date that the members will consult the documents, that you're going to speak with your legal teams to see if there's other ways that you would like to proceed and that the law clerk and your team can discuss. Would that be better? Would be more satisfactory?
Absolument, pour Sanofi.
For Sanofi, yes, absolutely.
Reasonable request to say that we would, if you adopt the motion, that we would do that. I personally think that's reasonable, to say that we would consult with you guys about whether there's other things that you want, for example, being in the room, etc. Sorry, well, I mean, that's my view. Yeah. Mr. Chair, do you have any time left, or is that it?
No, you still got just under 2 minutes.
Okay, so coming back again to I want to understand again, trade secret information pricing. Can you give me anything else specific that you're really, really concerned about? Like again, I'm again trying to see why in a locked room they would be of concern. But let me just understand what other elements specifically. Like or do you need your legal teams on that also? Okay. It's unfortunate your legal teams aren't here with you right now because they've had ample notice of this, but I understand, again, you came, you're not an easy job, and I think we've gotten as much out of you as we can today. So, again, I really, really thank you for coming.
Chancellor, I'm going to stop the clock. I'm going to interrupt you a little bit. Just to reinforce, I think, the view from this committee in Parliament, we're not obliged to negotiate with the companies to receive these documents. And so you're taking us down a path that has both me and the clerk nervous about setting up conditions for Parliament to view documents. So I'm saying this now because you still have a minute left. You can ignore what I'm saying or respond with this with questions. But this is a courtesy. It was a motion that was passed by the committee. I'm pleased we've heard from these witnesses. But this committee we're not required to negotiate with companies to receive any documents. So I think that's clear. But you've just taken us down to just a path here, and I don't want any false expectations left with any of the witnesses. Okay.
So, Mr. Chair,
over to you.
Mr. Chair, number one, I made clear amendment to the motion, so it would have to come through an amendment to the motion. Would that be there, and then the committee would have voted for it?
I want to clarify it.
I want to be clear. Number two, I'm not saying it's a precondition. I'm saying that if the committee says that the committee will review the documents in an unredacted day in the legal clerk's office, but that prior to that date it will consult with the companies to see if they have any ideas that the committee is willing to accept. That's fine.
Yeah, that's fine. I'm going to start the clock again. I just wanted to flag that with you.
I was not in any way suggesting it would be a precondition or that
I didn't want to leave the witnesses with that as well. But okay, so thank you.
Fair enough.
1 minute to go.
Okay, thanks. So, is there anything else? Do you want to make any last comments or last arguments to the committee? Anyone?
I'll start. I think I'll just go back to the context that is so important here. And it's so important because it's easy today, 3 years after the pandemic has started, literally 3 years, to think about the terms and conditions that were negotiated out of context. And I say this because it's so important because we already have forgotten how it was to be d'être au Québec avec un couvre-feu, to be in long-term care facilities that were completely closed and could not see your grandma or your parents or anybody. We've already forgotten, I think, the pain that the country has gone through as we went through the pandemic and how we turned every stone. Fabien talked about Pfizer bringing millions of doses of vaccines, more than they were planning for. Same thing with Moderna. We negotiated with the U.S. to get the first doses out of the U.S. to come to Canada so we could get the 2-dose summer that was promised to Canadians. I can tell you that we all have worked together with parliamentaries and government officials for the benefit and the greater good of Canadians. Je suis Canadienne, je viens de Trois-Rivières.
I'm from Trois-Rivières. I'm Canadian. We were working for us. And it's important to keep that in mind when we look at the contracts because hindsight is 20/20.
Context of the crisis where we're going through. And it's also important to understand that the confidentiality is super important in that context as well, because we were able to move fast
to have flexibility, to do what we needed to do for the country because we had safeguards. And changing the rules of engagement as we progress in a partnership makes it difficult to create a predictable and stable and secure environment. So I just want to leave you on that from my personal perspective, that I think context is very, very important. And I can assure you personally, craziest 2 years of my whole career, I would not do it any differently, but it was for the greater good of Canadians.
And thank you very much. That's I think a good closing argument on behalf of you and all your colleagues. I do want to thank you for coming in, both our two witnesses online and the three who are in the room. I know this went longer than expected. I appreciate your patience with us. I appreciate you appearing here. As it has been noted, these committees can be there can be curveballs, but I appreciate you coming in today and for staying for the extra hour. So you are. What I'm going to do is I'm going to suspend the meeting for about 10 minutes so folks can just stretch their legs, get some food, and I will excuse the witnesses. Thank you again. You're free to go as well, and we appreciate you being here. So I'll be back in 10 minutes. So, colleagues, I'm going to pick things up again. There was a general agreement that after the testimony we would move to our colleague's motion. I kept this meeting delay a little longer because I know there was some discussions going on. I think I'm going to turn to the motion sponsor, Madame Secretary Dingagné, and then I suspect it will go to Mr. Harshfather, but I'd like a little direction, please, because I was not part of these discussions.
Merci, Monsieur le Président. Certains mots.
Thank you. I don't want to delay the process too much, but I think that we've heard interesting testimony in as much as the arguments were commercial in nature in order to protect their competitive advantage. That's what every company wants to do, and that is why normally governments and institutions are there to defend their citizens and consumers. And I hope that we will have the support of MPs, government MPs, for a motion that was written with sensitivity and in a reasonable way. And so I hope that we'll have consensus. Thank you.
Mr. Housefather?
Oui, j'apprécie.
I really appreciate the collaboration of our colleagues, and I'd like to remind everyone that the MPs here are MPs, not government MPs. We're all MPs, and we're all here to cooperate as MPs.
You and I'll read it out. I have some small amendments to the motion, and they're all geared toward maintaining confidentiality because I think that is all of our goal. It was made very clear today to the companies that these documents will be retained as confidential. So I'll wait for the clerk to be back in his desk.
We're ready. Go ahead. Yes.
Okay. So, Mr. Chair, I would propose to amend the motion in Part A to say the words in the third sentence, and that no personal, mobile, electric, or recording devices, so adding the words or recording devices after the word electronic of any kind, so after the word devices of any kind, be permitted in the room that day, and that after the word day, and it would say, and that no notes may be taken out of the room.
The clerk has a question.
Yeah.
If I may, would you have that in writing?
Yes, I have it in writing. I'll hand it to you after.
Thank you very much.
And in the second paragraph, it would be the same changes that electronic or recording devices of any kind in line number 4, and it would end after the word copies, and that no notes may be taken out of the room. And then, Mr. Chair, I don't know how we would best amend that, but I think there would also just be an agreement that support staff at the meeting would not look at the documents, that the documents would be handed only to the committee members, and the support staff, one member's team could be in the room, but not to look at the document itself.
Can I just ask, you're talking political support staff that I assume would not cover the analyst or the clerk?
Right.
All right, that's political.
Well, my understanding from Natalie was that she means support staff to be that everybody gets their one person in the room in the meeting. And I just want to clarify that one person, just with the committee members, we may not have to actually amend the motion, would not actually look at the document itself. And I'll just hand the amendment to the clerk.
Sure.
Thank you. Thank you. Can you read my writing?
Just give me a second, Mr. Genuous. I'm going to just make sure the handoff is complete here.
Ask a question of you and the clerk.
Yes.
Apparently, Health has redacted versions of them. Can we get access to those?
Clerk from them, yeah.
Okay, thanks.
Yeah.
Yeah. All right. So before I go to Mr. Januous, I would just want to make sure the clerk is comfortable with the notes here.
Yeah, sure. I'll just need to
Okay.
draft it, but if the committee is in agreement, we just go.
I think we are. I do want to hear from a few more members. I also want to get the clerk's interpretation of the timing on this as well. But first, I'll hear from Mr. Januous.
Yeah, I mean, I'm curious what other colleagues think. I do think it's maybe a bit hokey to say, like, we can have staff in the room, but they can't look at the document. So, like, I come in with a research analyst from my team, and I have the document, but I can't give it to them. But then I'm going to read certain sections of it to get their opinion of it. They're still getting the information. Presumably, the purpose of having the staff in there is to have, conversation and research support. But it's just like I have to verbally read them the section so we can discuss it instead of them being able to look at it and read it at the same time as I read it. Like I don't know what's achieved by that. Like if you can't bring notes out of the room, if you can't bring any kind of recording devices in, of course you're not allowed to leak, and there are parliamentary sanctions associated with leaking. But beyond that, I think there are significant measures to prevent individuals or the one staff they bring in from leaking. And it's pretty standard that in camera we have a staff member. So
NDA for the staff.
I don't know. I think. I'm curious what others think, but it seems to me that it makes sense to have some minimal number of our support staff that are able to assist us in these things, as is the common practice. And if they're in the room already, then them being able to look at the piece of paper instead of have it read to them just seems sensible.
Yes.
To be frank, Mr. Chair, I think we have something in front of us that we should all agree on. I think this is something that we've collaborated on. I think we've come together in a very good way, in a very professional way, and have found a compromise. On Mr. Jennis's point, I get where he's coming from. However, if we are to take the idea of parliamentary privilege to its logical conclusion, it is a privilege that extends to members of Parliament. With all due respect to staff members, it is a privilege that is only held by members of Parliament. So we cannot, I don't think we can play around here in terms of having the documents viewed by staff members for that reason. It's either a sacrosanct principle or it's not. And this is something that I think only MPs, these are documents that only MPs ought to be able to see, Mr. Chair.
Oh, okay. I'll come back to you, but I had Mr. McCauley first. Go ahead.
Just a question for everyone is, I don't recall on the motion there it said how long we'd have access, and I'd rather have someone with me help me through. But that being said, if we have adequate time to access these, whether it's over a 1-week period, setting appointments with the clerk, several of us have days that are it's not available to us to get away from our other committees. So whether it's fine without staff, as long as we have enough time to actually review them all properly. So I'm not putting out a suggestion, but I just want to make sure that it's part of somewhere of our discussion, or somewhere of the understanding it will be over a decent period of time that we can get in, not 1 month, but at least maybe over a week, a couple hours here or there.
I think that's reasonable. Before I turn, and you can decide who's first, because I saw your hands up at the same time. Well, actually, I'll Ms. Shanahan, do you want to go first?
Yeah, just in line, because I've gone through this exercise once before in Ethics Committee, and so, yes, it was only the parliamentarians that were in the room, but it was over a course of a week, because we would just go in and spend how much time that we needed. to review. We left, we could come back and review again. And it was quite a stack of documents, I remember, so not something that you could do in just one sitting.
Yes, Mr. Housefather.
I just want to come back to the idea. First of all, I didn't put in the amendment anything to do with the staff because I figured that is just something that we would, agree on cordially. So the amendment doesn't deal with staff; it deals just with the recording devices, and the notes. But I was trying to be consistent in Section A. Only committee members. It's very clear that that it's for viewing by committee members only. In the first section, it's not staff. So in the second part, where it's the meeting with public services and procurement, I would believe to be consistent that only the committee members would actually be able to look at the documents because it's the same as in A, but the staff could be in the room to assist and discuss if they want and listen. But anyways, I hope everybody can agree with that because I think it'll make, an easier explanation and sale that we say only parliamentarians can look at the documents.
Oui, Nathalie. Oui, pardon, oui, Madame Sinclair-Desgagnés.
I'm happy that we have such good relationship within the committee. So, I agree that it's parliamentary privilege. Would you like to make an amendment or to add this notion of 1 week? Because in the motion right now, it only says a day. So, friendly amendment. And I agree with the principle. I just want to make sure, is this a new amendment on top? Is it a sub-amendment? What is it? Yeah, it's a friendly amendment. And you can just add it to what I gave you to say that it would be available at the clerk's office from only members of the committee for a period of 1 week.
On va remplacer jours par semaine.
Yeah, no, I want to make sure. Yes, Mr. Desjardins.
Thank you, Mr. Chair. I think that if the members of the committee are satisfied with this iteration, with the addition of Mr. Housefather's last portion in regards to the week that Mr. Macaulay mentioned, and with the mover, I think I'm satisfied with concluding debate at this point.
Okay. Before we take a vote, I just want to check the timing on this. I really don't want to come back here on, say, Good Friday, and there are a few tripwires in this that we can maybe agree to change with the UC. But I believe it requires the documents be sent to the clerk's office within 15 days. Is that right, Mr. Clerk?
Yeah, it is.
Now, does the motion say when we have to look at it, or they just have to be delivered to you?
The department would have 15 days
Yes.
to actually send those documents to me,
Right.
and then when I do receive those, the committee would have to now decide for a week for those documents to be consulted in my office for within 15 days after they
After you receive them?
Yes.
Okay, so if they are due on the 7th of April, we would have till the actually the 24th. I'm going to count, or at least the 22nd.
If I may,
Yes,
Chair,
please.
that is something that could be done again if we do receive those documents in the week of April the 17th.
Okay.
Or even if the committee do agree, we could meet and just agree
Well,
to do that on the 24th.
Just to be precise, I said they're due by April the 7th. That's 2 weeks from today, correct? Or
Yes,
yeah,
if
that's
the
15
motion
days.
is adopted.
Yes,
as
yes, I'm
is
assuming
written,
yes.
Yes.
And then and then 15 days after that is when we should review them.
Within 15
That's fine.
days.
I need to get over another week, so we don't have to be back here just after Easter. Yes.
Chair, I'm anticipating that we're moving towards a vote. Before we do, could we just have the clerk read the...
We're going to get to that. Yeah, I'm not
Okay.
going to rubber stamp this. I just want to make
all
sure we got everything done, so we
Yeah,
just have
just
yeah.
to read
So
what we're voting on.
Okay, maybe I should raise this now, just so. So the auditor has sent a letter asking to be to be on site for any in-camera discussion. This is something that is kind of outside this motion. We can accept or reject that, but I wanted Auditor General. I mean, she's already been sworn to secrecy on this. She can, notwithstanding what she said to us in public, but not revealing contents, she is able to discuss these in camera with us. So that might be helpful as well. So I just wanted people to be aware of that that offer.
After the fact or during that week?
I would do it all in the week. So let's get back to this motion, and then we can talk about scheduling a little bit. But I just wanted folks to be aware of that. So could you read the motion again, and we'll turn to hopefully agreement on it.
You want me to read as a whole or from the start? Because the same two paragraphs.
Mr. Frank, I think it's the whole from the start.
Let's make sure that we know what we're voting on in crystal clear terms.
1 second. So it reads as follows, that pursuant to Standing Order 108-3G, the committee undertake a study on of the contracts between Public Services and Procurement Canada with Moderna, Sanofi, Pfizer, Medicago, AstraZeneca, Johnson & Johnson, and Novavax for the supply of COVID-19 vaccines. Auditor General's Report 9 and 10. That, pursuant to Standing Order 108-1, the committee order Public Services and Procurement Canada to produce a copy of each of the said contracts by forwarding them to the clerk of the committee within 15 days of the adoption of this motion, provided that they are free of any redactions. That, when these documents are received by the clerk, they be available at the clerk's office for viewing by committee members only for 1 week to be designated. By the committee no later than 15 days following the receipt of the contracts, under the supervision of the clerk, and that no personal mobile, electronic, or recording device of any kind be permitted in the room that day, and that no notes be taken out of the room. Representative of Public Services and Procurement Canada be invited to appear for a 2-hour in-camera meeting, and that during the meeting, only committee members and support staff required for the meeting be permitted to attend, and that no personal, mobile, electronic, or recording devices of any kind be permitted in the room during the meeting. That during the meeting, numbered paper copies of the documents be given to committee members who are present in person by the clerk at the beginning of the said meeting, and that these copies be returned to the clerk at the end of the meeting, and that the clerk be instructed to destroy the said copies, and that no notes be taken out of the room. End of the motion.
So clerk, how do we proceed with what has been labeled a friendly motion? Is it just up to the...
So I would like to put on the record that there's no such thing as a friendly amendment,
that's what I thought,
but a motion was brought to the floor, and I think now you have agreement between the members of the committee to just adopt that motion. You could decide to vote on it on a recorded vote, or just adopt it by unanimous consent.
Joe, on the full motion.
On the motion that I was just asked.
So I don't need to first vote on the amendments to the motion.
Well, again, we could vote on the amendments first of Mr. Housefather that he just brought, and then the motion.
Let's do that. We're going to vote. Yes.
Or we could just do UC on what you just read.
Okay.
Let's just do the UC.
Do I have UC on the motion that was just read by the en français? Okay. On va répéter en français, s'il vous plaît. On va.
I have to say, je dois vous avouer là-dessus, je vais devoir.
I have to tell you that I would have to translate it myself. We have experts here. So if you listen to the interpretation, if you listen to the French, it should have been okay. I'll try to translate it live, but I received the amendment in English only, so the interpreters interpreted into French.
It's one of my many careers.
Very good.
Yes. I have no problem with that. The clerk's just going to get his thoughts together for this in French, which is completely understandable.
Chair, while that's happening,
Yes.
Can I just clarify the first possible week that we'll be looking at these documents is the week that we're back here in Ottawa, the 17th
Yes.
of April.
The motion kind of, I think, compels us to do that first week.
Okay.
And what I'm thinking is having the in-camera meeting on the 20th. Again, this is an idea. On the 20th with Representative Public Service and Procurement Canada. And then that would be after QP, so 3:30 p.m. in the afternoon. And then allowing members on the previous Monday, Tuesday, or Wednesday, we can either set a time, it could be the committee on Monday, to review the documents before that, or we could just make individual appointments and go in and see the clerk or something like that. But go ahead.
Yeah, I was going to ask that because it's the documents will be available in the clerk's office, and there's a whole setup normally when that happens. Yeah.
So we can have a discussion about that. About do we do it at the committee time on the Monday, or do we just individually go in and see the clerk? I'd have to speak to him about that as well. Yeah. Yeah. Oui, Madame.
Juste enlever une contrainte,
Knowing that we have some weeks in our writings, can we take out the 15 days so that we can agree on the week and that we're not constrained to the week of April 21st? I will be overseas.
Work with Mr. Housefather on some new language. So you're not here that week.
Peut-être, Monsieur le Président, si on dit dans la première...
Maybe if we say, where we say that it's 15 days.
No later than 30 days. Et là, ça te donne la flexibilité.
That way you have the flexibility if we speak of 30 days and not 15 days.
Oh, I look like a big boss here on that TV.
I'm going to suspend for 1 minute so I can get a call.
Je vais prendre un café, une suspension d'1 minute.
The clerk en français, not
Our motion?
other language. We've made a small change that we will be able to review it over a period of 30 days, or we'll find a week within a 30-day window. But here it is.
Donc, la motion se...
The motion, pursuant to Standing Order 1083G, the committee undertake a study of the contracts between PSPC with Moderna, Sanofi, Pfizer, Medicago, AstraZeneca, Johnson & Johnson, and Novavax for the supply of COVID-19 vaccines. Auditor General's Report 9 and 10, that according to 181 of the Standing Order, that we ask PSPC to produce a copy of each of the agreements by sending them to the clerk of the committee within 15 days after adopting this motion, that when these documents will be received by the clerk, that it be available at the clerk's office for consultation by the members of the committee only for 1 week. To be designated by the committee at the latest 30 days after receiving the contracts and under the supervision of the clerk, and that no electronic, personal, or recording device be allowed in the room, and that no notes leave the room. That's why it's really good to have the text in writing. The representatives of PSPC would be invited to testify for a 2-hour meeting, in-camera meeting, and only members of the committee will attend, as well as necessary support staff be authorized to attend, and that no mobile, electronic, personal device or no recording device be allowed in the room during the meeting, that during this meeting, paper copies be given to members of the committee present in person by the clerk at the beginning of the meeting, and that these copies be given to the clerk at the end of the meeting, and that they be given the instruction to destroy the copies, and that no notes leave the room. Consentement.
I hear no opposition. That is passed. Thank you, Mr. Clerk. Thank you, everyone. All right. Très bien. Hold on. We will soon. So, Clerk, you will send that off first thing in the morning, and the countdown will begin. I'm just going to do some very quick business. Yes, do you have a point you'd like to make, Madame Sinclair?
Je tiens vraiment à faire le...
I really want to make my point, and we heard this earlier. We are the first parliamentarians in the world to have access to these unredacted contracts. I'd like to congratulate all the MPs for their cooperation. Sometimes it's worth being ambitious, and I think it's going to be worth it for the confidence of Quebecers and Canadians towards their institutions.
I do, and I want to take a second before I just, so I don't forget later, I do want to thank the staff for being here for these long couple meetings over Thursdays, and for the translation team as well for the work you do there, and also just helping us make sure we had this motion down. So what I'm going to do is Monday, as you know, the Auditor General is coming in. It's an unusual day on the Monday, which means we're actually going to have the Auditor General before us before she even goes before the media. So we have the lockup that morning, which is open to all parliamentarians and staff. At 10 a.m., she's going to appear before an ad hoc committee. It's not this committee, which I chair. That's open to, again, all members and senators for, again, an in-camera review. Then at 11, we have committee. Now, we actually won't start that committee until the documents are tabled in the House, probably at 11:10, 11:11. So there'll be a bit of a lag, and then once it's tabled in the House, our meeting will begin, and the auditor will make remarks and then go to questions from committee members. That will last for approximately an hour. After that, I'm going to suggest that we have a subcommittee meeting. So members, unless they really want to stick around, will be excused. We can then talk about the documents that were tabled and where we're at just with other committee business, just to kind of get caught up on things. And then Thursday of next week, the clerk's been working on this. We're likely going to have Report 7, cybersecurity of personal information in the cloud, and that will then take us to the recess. So we're in pretty good shape just in terms of being efficient with our time. Does that sound good? Okay. Then I'm going to look for an agreement. Anything else, clerk? No. I'm going to look for an agreement to adjourn, please. I see it. We are adjourned. Thank you.